From the daily list, under heading for judgment, item 1, WPS 378 of 2023.
Within list.
Please hold on. Your candidature will be considered only if there was a vacancy in your category against the advertised post.
Yes, sir.
It cannot be considered against future dates.
Yes, sir. Not against future.
I have relied upon their own circular, wherein they have stated that the effective date of the circular would be, they issued a circular in 2011, in the month of November 2015 also.
But wherein one opportunity was to be given, if I'm not wrong, to all the candidates to come and give up their certificates, correct certificates.
Yes, because it decided the date of effectiveness.
Yes.
Prior to that, there was complete
Chaos.
silence on that. Wherein it was stated that the last date of submission, if it is beyond that cutoff date, then the candidature will be considered as per the new circular. Pankaj, I have put my signature in all the pages. You upload it once your dictation time is over.
Next.
Yes.
May I mention for item number 68 within list. This is the dismissal matter of the with the Union of India. So any time today.
Where is the other side? Where is the counsel for the other side?
I will inform also.
Call them.
Watch out.
Under heading for final disposal, item 2, criminal revision 258 of 2019.
Yes, petitioner.
May it please your lordship, Lord. After Holi of this opening, Lord, I pay my respects.
Happy Holi to all of you.
Happy Holi. Lord, this matter was heard on the last occasion as against the order of maintenance. The husband, Lord, is before this. Now the point for your lordship's consideration was that without any ascertainment of the income, Lord, he is a poor laborer, Lord, and 3,000 per month has been awarded as maintenance. And she is also.
He is a mason.
Pardon?
He is a skilled laborer. Mason. Right?
Lord. Lord, of course, it is the responsibility is there, Lord. But I will pray, Lord, in the facts and circumstances, if at all something can be reduced.
Criminal revision number 258 of 2019. For Mr. Rajiva Sharma, learned counsel appearing on senior advocate, appearing on behalf of the petitioner. Nobody appears on behalf of the opposite parties. This petition has been filed against the judgment dated 8/1/2019, passed by learned Principal Judge Family Court Pakut in original maintenance case number 65 of 2017, whereby the learned court has allowed the application under section 125 of CRPC filed by opposite party number 2 and has directed the petitioner to pay monthly maintenance allowance of rupees 3,000 per month from the date of the order.
Your Lordship, Lord is passing some on deduction, Lord?
No.
No.
I will pass my order. I heard you.
No, Lord,
Please do.
if not deducted,
Please
then
do.
I will withdraw.
After some argument, the learned counsel for the petitioner,
Yeah.
senior advocate Mr. Radiva Sharma, seeks permission to withdraw this petition. Accordingly, this petition is dismissed as withdrawn. Prayer quote कर देंगे. Let this order be communicated to the concerned court forthwith. Yes.
Sign कर लीजिए. Item 3.
Are you there in this case?
No, I am in serial number 3.
चलिए, nobody appears for the opposite party. दोनों का इसमें पहला वाला केस में appearance of nobody has appeared on behalf of opposite parties.
Item 3. Criminal Revision 305 of 2019.
In this case, there was a direction to seek instruction whether the case is pending or be disposed of not. It has been disposed of on 23/6/2023 in the trial court, and the judgment has been delivered.
Criminal Revision number 305 of 2019. Nobody appears on behalf of the petitioner. The learned counsel appearing, नहीं, इसके बाद लिखिए. This petition has been filed challenging the order dated 22/1/2019 passed in GR number 17 of 2017 arising out of Mango PS case number 2 of 2017 by learned judicial magistrate first class Jamshedpur, whereby the learned magistrate has been pleased to reject the discharge petition under section 239 of CRPC, and the petitioner has been directed to appear physically on the next day for framing of charge. The learned counsel appearing on behalf of the state has submitted that the case before the learned trial court has already been concluded by judgment and judgment dated
23/6/2023.
2023 has already been passed. He submits that the present case has become infructuous. Considering the aforesaid submission made by the learned counsel for the state, this petition is dismissed as infructuous. Communicate.
लास्ट में जो स्टेटस रिपोर्ट भी आया था लगाया है.
स्टेटस रिपोर्ट सही से नहीं दी है. आपने चेक किया है ना?
जी.
Item 4. Criminal Revision 316 of 2019.
Permit to withdraw this petition, madam.
Criminal Revision number.
With reverting to this all the points at the appropriate stage.
Criminal Revision number 316 of 2019. The learned counsel for the parties are present. This petition has been filed challenging the order dated 7/2/2019 passed in connection with Boru PS case number 27 of 2017 corresponding to GR number 66 of 2017 and ST number 321 of 2018 by the Learned Court of Sessions Judge Sahibganj, whereby the petition filed under section 228 of CRPC has been rejected. The Learned Counsel for the petitioner on instructions seeks permission to withdraw this petition. He submits that liberty may be reserved with the petitioner to raise all points at appropriate stage in trial. The Learned Counsel for the state has no objection to the prayer made. Accordingly, this petition is dismissed as not pressed. However, dismissal of this petition will not prejudice either parties, and it will be open to the petitioner to raise all points before the learned trial court at appropriate stage.
Okay. Okay. Item 5, criminal division 441 of 2019.
But in this case, the petition has challenged the order by which the discharge application was rejected. Earlier also, Your Lordship, he has filed a revision against the order, Your Lordship, of discharge, which has been allowed and the matter was remanded back to the court.
Where is that document?
That's already with you. Please. The case is of 440.
Yes.
The case is of 440. It has been alleged, Your Lordship, that on 23/2016, one truck loaded with iron scrap was seized. The material was, Your Lordship, only iron scrap. And it was suspected, Your Lordship, that the same was stolen. For that, Your Lordship, affair has been issued in the year 2016. After that investigation done, during investigation, we have produced certain documents before the investigating officer that we have purchased this iron scrap from a particular industry.
Is it a part of the case diary?
Yes, that is a part of the case. That is my case. That is my only case. And that has been discussed in the impugn order also. Then the police eventually cancelled the impugn order.
Yes.
Page 20. Learned counsel for the accused petitioner submitted that the petitioner are innocent and have committed no offence as alleged in the FIR. The officer in charge of this case has not properly investigated the case and submitted charge sheet against the accused person suppressing the true fact which come under the investigation. There is no allegation of any theft and therefore no case is made out under section 440. Moreover, the stolen property has been defined under section 14 of the CRPC, IPC ONHL. But in the investigation, it is found by the officer in charge that the materials belong to RK company, and the fact is also mentioned in paragraph 40 and 41 of the case diary.
Who is RK company?
RK company from whom we purchased, we produced document, informant police went to the RK company and verified this fact whether I purchased the same or not. Then it has been mentioned in the case diary, yes, it has been purchased and it has been transported. Because it was only iron scrap.
Who filed the FIR? Who filed the FIR?
After
Where
the
is the FIR?
police during investigation, only the police has suspected that during search and seizure, no document has been produced and it was suspected that it is the stolen one. It was only the iron scrap.
Place the FIR.
Yes.
Where is the case diary? Respondent? Yes, are you appearing for the state? What is the present stage of the case?
In this case, Your Lordship, only the charge sheet has been submitted, the discharge application was rejected. We not able to appear, then subsequently the court has changed and NBW has been issued. Earlier, Your Lordship, we were released on anticipatory. We could not appear before the court because of the change of the court, then NBW was issued. 40 and 41 of the case diary, Your Lordship, very particular. That the police went to the place of occurrence, police has verified the same. 41 and 41.
Truck belongs to whom?
Trucks belong to this petitioner.
To the petitioner.
Petitioner. And beside this, nowhere in the entire case, Your Lordship, it has been mentioned that this article belongs to whom. Same and except this petitioner who is the claimant of the article. And this RK company, nowhere it has been mentioned in the entire case diary that if I am not the owner, who else can be the owner of the article? Or could be the owner of the article? Admittedly, 379 may not be required each and every case of 440. But where, Your Lordship, when we are able to produce the document showing
Which
that
paragraph of the case diary are you relying on?
40 and 41. 40 and 4. The state has filed counter, but they have not disputed this fact.
Yes. Read para 40 and 40.
इस कांड के अनुसंधान के क्रम में पता चला कि ट्रक पर लदा स्क्रैप आरके कंपनी डिमना रोड मानगो जमशेदपुर से लोड किया गया तथा एलआरडी थाना नामडी जिला सरायकेला जा रहा था। एलआरडी कंपनी में स्क्रैप नहीं लेने के कारण पुनः स्क्रैप लेकर ट्रक जमशेदपुर ला रहा था। इसका सत्यापन के लिए जमशेदपुर के लिए प्रस्थान किया। इस क्रम में अनुसंधान के क्रम में आरके कंपनी डिमना रोड मानगो जमशेदपुर पहुंचा तथा कंपनी में जाकर पूछताछ किया तो कंपनी द्वारा दिया गया चालान प्राप्त किया तथा उसको अवलोकन किया तो पता चला कि आरके कंपनी जमशेदपुर से माल स्क्रैप ट्रक पर लोड हुआ था तथा एलआरडी निम्डी गया था तथा कंपनी निम्डी से स्क्रैप नहीं लेने के कारण पुनः लौट के जमशेदपुर आ रहा था। जमशेदपुर से प्रस्थान किया एंड ड्यूरिंग दैट ट्रांजिट ओनली द आर्टिकल हैज बीन सीज्ड एंड द केस हैज बीन लॉन्च्ड।
आपका चालान कहाँ है?
चालान है दैट वी हैव प्रोड्यूस्ड बिफोर द आईओ एंड आईओ हैज वेरीफाइड द सेम।
Where is the चालान?
चालान विच इज क्लियर।
इसमें होना चाहिए ना केस डायरी में चालान।
केस डायरी में तो पुलिस का काम है ना। ये तो पुलिस का काम है कि हमको कैसे इम्प्लीकेट कर रहे हैं, हम उनको डॉक्यूमेंट दिखा रहे हैं, किस बेसिस पे हमको इम्प्लीकेट कर रहे हैं, तो उनका केस बनाना है, उनको प्रोड्यूस करना है। हम तो उनके सामने डॉक्यूमेंट दे दिए, वो तो हम उनके सामने डॉक्यूमेंट दे दिए, उनको वेरीफाई करना है।
Where is the चालान? चालान दिखाइए।
दैट लॉ में चला।
Who is SK Enterprises?
SK Enterprises और actually the Mrs. Kumar Enterprises has purchased the same because RK Enterprises से RK Traders से एक आर्टिकल परचेज हुआ है।
आप कैसे लिंक्ड है SK Enterprises?
हम तो गाड़ी मेरा था, हम ट्रांसपोर्ट कर रहे थे आर्टिकल।
ट्रांसपोर्टेशन का प्रॉपर डॉक्यूमेंटेशन होता है। It is not like this.
तो ये तो सारे डॉक्यूमेंट है मेरे पास, हम फाइल कर देते हैं।
It is essentially a matter of defense.
At this moment, you actually kindly see. At this moment,
I'm seeing it.
in
You
this
see
case,
these kind of things. It is essentially a matter of evidence for you.
in these cases,
You might, for if you are a transporter, then there has to be.
In this case, it has been mentioned.
If you are a purchaser, then this particular challan should have been in your name. We do not know who is SK Enterprises, and this document is not a part of the case.
It's a case of 440 only. If it is the iron scrap, it is the iron scrap. Yes, और ये किसने मेरा बेल एक आईए पिटीशन भी हम फाइल किए थे इस केस में।
कुछ
आईए एक फाइल किए थे।
नहीं, आप it is essentially a matter of your defense. If you want a reasoned order, I will give you a reasoned order.
In this case, we have filed one IE also because during the pendency of this case, LBW has been issued.
No, उस IE से हमको कोई मतलब नहीं। आप
सर IE फाइल की अगर वो
क्रिमिनल रिवीजन में 2 प्रेयर नहीं हो सकते।
तो वो उसके लिए हमको लिबर्टी दे दिया जाए।
वो तो आपका IE है, आप अपना लिबर्टी है आपके पास।
नहीं,
You
IE
want
है।
this? I will say that IE I will not allow. You will have your liberty as per law.
IE I will withdraw your lordship. I will withdraw to raise that appropriate by
How about-
filing an appropriate.
How about criminal revision?
That will also I will withdraw to raise on this point at appropriate stage.
Criminal revision number
Or
4.
it may be decided on merit, your lordship. It may be
It
decided.
will affect your trial.
I don't think so, your lordship, because the 414 they have to prove
Okay,
before
then
the
I will pass out on it. It's no problem.
because they'll have to prove the case before the court only.
That's it. Criminal revision number
ठीक है,
4.
withdraw कर लेते हैं भाई। I'll withdraw.
नहीं करिए ऐसा, बहुत हार्म हो जाएगा। क्रिमिनल रिविजन नंबर 441 ऑफ 2019। इसीलिए डिस्चार्ज में ऑर्डर पास करने के पहले हम जरूर एक लिबर्टी देते हैं। आई डिस्क्लोज माई माइंड एंड गिव द लिबर्टी ऑल्सो विथ IE नंबर 11703 ऑफ 2023। Criminal revision number 441 of 2019 has been filed challenging the order dated 17/12/2018 passed in GR case number 302 of 2016 arising out of Chandil PS case number 53 of 2016 by which the discharge application filed by the petitioner has been rejected. So far as IA number 11703 of 23 is concerned, the petitioner has prayed to add one more prayer to the criminal revision application in order to challenge the order by which non-bailable warrant has been issued against the petitioner, white order dated 25/2023,
And bail has been cancelled.
and the bail bond furnished by the petitioner has been cancelled.
Bail has been cancelled.
And the bail has been cancelled on the ground that the case was running for framing of charge since 11/9/17. The learned counsel for the petitioner on instructions seek permission to withdraw the revision application CR number criminal revision number 441 of 2019 and also IA number 11703 of 2023 by submitting that for the prayer made in the IA, we shall take appropriate steps.
By filing a fresh application also.
Appropriate steps, whatever. And so far as withdrawal of criminal revision number 441 of 2019 is concerned, some observation be made so that withdrawal of this case may not prejudice the case of the petitioner before the learned trial court. The learned counsel appearing on behalf of the opposite party state has no objection to the prayer made by the petitioner. Accordingly, criminal revision number 441 of 2019 is dismissed as withdrawn. However, liberty is reserved with the petitioner to take all points which have been taken in this petition and other points which may be available to the petitioner under law before the learned trial court at appropriate stage. So
The
far as
certified- certified copy we have filed in with IA, that will be returned to your signature.
So far as IA number 11703 of 23 is concerned, the same is also dismissed as withdrawn and liberty is reserved with the petitioner to take appropriate steps in connection with order dated 25/2023 in accordance with it.
Signed.
Item 5, criminal division 658 of 2019. Item 6.
Mr. Sinha, it is your case.
Item 6.
In this case, my lord, no objection as petitioner has taken no objection from me, long back in the year 2020 itself.
What is the present stage of the case?
It is not showing in the evidence.
Criminal revision number 658 of 2019. Learned counsel for the petitioner, Mr. Sekhar Prashad, has submitted that the petitioner has taken no objection from the petitioner way back in the year 2020. But no fresh wakalatnama has been filed in the present case. Upon उसके बाद लिखे, this petition has been filed challenging the order dated 6/4/2019 passed by learned additional sessions judge Roman IV Dhanbad in connection with ST case number 159 of 2018 arising out of CP case number 683 of 2008, whereby petition dated 26/2/2019 filed by the petitioner/complainant under section 311 of CRPC to permit/allow the petitioner to examine additional witnesses, namely Akash Kumar Sinha alias Sonu and B. Mohammad Samsher Alam, has been dismissed. Upon going through the impugned order dated 6/4/2019, this court finds that the petition dated 26/2/2019 was filed on behalf of the complainant under section 311 CRPC to examine the aforesaid two persons as witnesses. The petition was opposed by the defense. The learned court observed that during trial, the complainant had examined himself and two other witnesses as PW 1, 2, and 3 respectively, and none of the witnesses had stated that Akshay Kumar Sinha and Mohammad Samsher Alam were the eyewitnesses to the occurrence. Rather, none of the witnesses had mentioned about the aforesaid two persons. And the learned court was of the view that there was no material on record to show that these two persons had either witnessed the alleged occurrence or were aware about it in any manner. The learned court, in the aforesaid background, recorded as follows. Then it recorded that these witnesses were neither cited as witnesses in the complaint petition, nor any of the examined witnesses, including the complainant, had stated their name in their respective depositions, and was of the opinion that the complainant had filed the petition with an intention to linger the trial of the case. This court finds that the impugned order dated 6/4/2019 is a well-reasoned order, and there is no illegality, perversity, or irregularity in the impugned order. Accordingly, this petition is dismissed. Communicate. State appearance to confirmation.
Under heading for orders with effect, item 7, WPS 988 of 2023.
Yes, petition.
Your Lordship, the matter has already been referred to the larger bench. The defect was related to the complete address may be mentioned in detail of respondent number 5 to 9. They are the selected candidates. Whether the JPSC will give their address because we have no source of information.
What is the matter about?
The caste certificate related matter, Your Lordship.
What all caste certificates are not subject to larger bench.
Yes.
Okay, what is the matter about?
Matter is, Your Lordship, it is related to advertisement of combined civil services examination. Your Lordship. His case was rejected due to non-submission of non-creamy layer certificate which has been issued after the last date. And he has secured less, and as such his candidature was considered under unreserved category, and in unreserved category he has secured less.
So this issue has been decided by this court recently. This matter is not subject matter of larger bench.
The matter related.
Ram Kumar Girjoya's case is
Ram
subject matter of larger
Yes.
bench, right? All the judgments pronounced
Similar
following
matter
that.
related to the same advertisement, Your Lordship, has been referred in that larger bench.
Similar matter means which matter?
Similar matters were filed.
We do not know. We have decided it recently. Who is the advocate on record? Call him. अभी हम डिसाइड किए हैं ना,
Yes.
लेके आइए जज।
शेर मोहम्मद
हमको याद नहीं है पार्टी का नाम। लेकिन डिसाइड किए हैं आपके वहाँ पर अपलोड हुआ होगा। क्रीमी लेयर के लिए बोले हैं कि जिस दिन एप्लीकेशन फाइल किए हैं उस दिन उसका स्टेटस देखना ज़रूरी है, राइट? आई थिंक दिस इज व्हाट आई हैव हेल्ड, आई डोंट रिमेंबर। यू गेट दैट जजमेंट, यू कॉल हिम।
Item 8, WPS 3240/2023.
All the defects have been removed, madam, except court fees money. And for that,
प्लीज
जी,
क्या हो गया?
107 petitioner है, हमारे फाइल एंड
बड़ी अच्छी बात है। क्या प्रेयर है?
Prayer है हमारा to grant with consequences, notional seniority.
एवरी पर्सन हैज इट्स ओन कॉज ऑफ एक्शन। नहीं चलेगा, सबका सिर्फ फाइल करिए। Every person in case of seniority has his own cause of action. बताइए। Seniority list is under challenge.
No,
Then
इसमें क्या हुआ कि on the part of the delay of that one, हम लोग का appointment delayed से हुआ.
नहीं चलेगा। Every person has its own cause of action. कायदे से तो इतना सारा मिक्स ही नहीं करना चाहिए। Office is not raising any objection. You remove the defects.
Yes.
How much time do you need?
2 weeks. खाली court fee जमा करना, बाकी सब remove.
I do not. WPS number 3240 of 2023. Learned counsel for the petitioner prays for and is allowed time till 16th of April 2024 to remove the surviving defects peremptory. If the defects are removed within the aforesaid time, post this case on 23rd of April under appropriate heading.
Item 9, WPS 6322 of 2023.
One of the defects that will remain is the respondent number 1 represented by the someone.
Sorry?
So for my defect is concerned, my part is concerned, not if I already remove all the defect. Initially, whatever pointed out by the registry.
What is the surviving defect?
Respondent number 1 represented by someone else.
थ्रू ब्रांच मैनेजर रेस्पोंडेंट नंबर 2 को किए हैं, तो रेस्पोंडेंट नंबर 1 को इनका मैनेजिंग डायरेक्टर चाहे कुछ तो होगा, चेयरमैन होगा, somebody must be representing them. Then on the last occasion you said that all the defects have been removed.
So for my part is concerned, because this defect will be.
You are not aware of one incident which had taken place, and this defect is pursuant to certain orders passed by this court. That company has to be represented through somebody, either the managing director or the chairman. Suppose tomorrow if we want to initiate a contempt proceedings against the company, who will be there? How could you make a submission on the last day that you have removed all the defects?
I am able to understand this defect.
If you are unable to understand the defect, you would say so that you are unable to understand the defect. But you could not have made a submission that you have removed all the defects.
Initially only 3 defects are there.
No. बिना रिकॉर्ड पढ़े ना सबमिशन मत किया करो डिफेक्टिव केस and impose some cost on you. Why did you make this submission on the last date?
Defect lordship initially only 3 defects.
No, this defect was also there. Defect number 4. Respondent number 1 may be represented by someone,
Defect lordship
which is dated 18/3/2024.
Defect online only 3 defects are shown. So that is the thing which I understand.
यहाँ पे डिफेक्ट में केस लगा हुआ है, फाइल भी नहीं देखते हैं मांग कर।
नहीं सुबह देखें कब हम ये मेंशन कर रहे हैं. Respondent number 1 represented by someone else. So give the 2 week time, that is removed.
2 week time. I'll give you 2 days time. WPS number 6322 of 2023. Counsel for the parties are present. Although a submission was made on the last date, that is on 23/2024, by the counsel for the petitioner that he has removed all the defects, but the same is factually incorrect. Today, the counsel for the petitioner, however, time till 8th of April is granted to the petitioner to remove the surviving defects, preemptory, if the defects are removed within time. Post this case on 9th of April under appropriate heading.
Under heading for orders, item 10, Criminal Revision 572 of 2019.
Your Ladyship, I seek your permission to withdraw this case.
Criminal Revision number 572 of 2019. The learned counsel for the petitioner MS Shrestha Priya Jha seeks permission to withdraw this petition under instructions of advocate on record Mr. Abhishek Prasad.
Yes.
Who has instructed you?
Mr. Nilesh Kumar.
Mr. Nilesh Kumar. Counsel for the respondent state has no objection to the prayer made.
Your Ladyship, liberty may be given to these necessary steps.
Accordingly, this petition is dismissed as not pressed. You wanted to withdraw, no? Dismissed as withdrawn. However, withdrawal of this case will not prejudice either parties, and liberty is reserved with the petitioner to raise all points which have been raised in the present petition and any other point which may be available under law before the learned court at the stage of trial, before the learned court at the appropriate stage. This petition has been filed against order dated 12/4/2019, by which discharge application filed by the petitioner has been rejected in connection with ST case number 92 of 16, which was preferred by criminal miscellaneous application number 140 of 2018, arising out of Lohardaga PS case number 51 of 16. बस इतना ही काफी. Communicate.
Thanks, Item 11, Criminal Revision 584 of 2019.
With the Chief's kind permission, I would like to withdraw this Criminal Revision number 584 of 2019. Prerna Jhunjhunwala, advocate, under instructions of Mr. Indrajit Sinha, seeks permission to withdraw this petition. This petition has been filed challenging the order dated 6/4/2019, passed by the court by learned AJC, learned AJC Roman 13 Ranchi, whereby petition under section 227 of CRPC for discharge has been rejected in connection with Sukhdev Nagar, within bracket Pandra, bracket close, PS case number 228 of 2018, corresponding to GR case number 2617 of 2018, arising out of ST number 35 of 2019, in criminal miscellaneous application number 273 of 2019. The learned counsel appearing on behalf of the opposite party. Are you there? Proxy nahi chalega, please don't. The proxy. Nobody appears on behalf of the. Sorry? He is not there. We will not record appearances like this. Nobody appears on behalf of the opposite party. However, considering the prayer made, this petition is dismissed as withdrawn. It is observed that withdrawal of this case will not prejudice the case of the petitioner before the learned trial court, and it will be open to the petitioner to raise all points at the stage of trial.
Duration is going on at the stage of evidence. The evidence is
Trial is on.
Under heading for fresh filing, item 12 WPS 6010 of 2023.
The petitioner prays for directing to the respondent issue appointment letter in favor of the petitioner. Lordship, petitioner is qualified in the combined graduate trained teacher competitive examination 2016 for district Godda. Lordship, advertisement number है 21/2006.
The petitioner was supposed to produce certain documents.
This she did not.
From where do you say that she did not? Have you filed any counter
I will
affidavit?
file counter.
You filed a
I
counter.
will only pray for time for file. Today I will only pray. Mark.
WPS, have you received instructions that she did not file?
No, they said that this is the office information. Presently, JSSC is being investigated by SIT for questioning. Whole office is in dislike. Almost on every table there is investigating officer sitting. Why this leaked out? So I am in a little bit of trouble at the moment. But they said, हमको जो सूचना है वो ये है, आप टाइम मांगिए, इसलिए हम टाइम मांग रहे हैं.
WPS number 6010 of 2023. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that a letter dated 24/9/2018 was issued to the petitioner as there was difference in the name of the petitioner in BA certificates and mark sheet, and he was directed to remove the defect and explain by 1/10/2018. It is a case of the petitioner that in compliance of the direction, the petitioner submitted the amended certificate and mark sheet on 1/10/2018 and removed the defects as pointed out by the Commission at the time of verification. Counsel for the respondent number. You will be respondent number. Mr. Singh, you are respondent number 3 to 6, 3 to 5. The learned counsel for the, both of you file your counter. The learned counsel.
4, 5.
Right?
3, 4, 5.
इतना से हो जाना चाहिए.
Yes, yes.
The learned counsel for the respondent number 3 to 5 is directed to seek instructions and file a counter affidavit in this case. At this stage, no counter affidavit is called for from the state, Jharkhand. Let the aforesaid counter affidavit be filed by 24th April.
थोड़ा टाइम और दे दिया था तो ठीक है, अदरवाइज जो कोर्ट का ऑर्डर होगा हम पालेंगे.
By 24th April, oppose this case on 30th April under the heading for final disposal.
Item 13 WPS 6531 of 2023.
%10% of pension has been withheld on ground that petitioner is facing criminal proceeding in the court. This is the issue. Issue has been settled by the Honorable Supreme Court in 2013. On this ground,
After taking into consideration the amendment,
in that case also there was amendment that was passed by Supreme Court because the notification cannot amend the rules. Ground was taken.
where is that judgment, Supreme Court
I
judgment?
have an explanation. Paragraph 35, page number 26. Having due regard to the above decision, we are of the opinion that the right of the petitioner to receive the pension is property under section 60. And when we are
No, we want to know about the amendment. Where is the discussion about the amendment?
Yes, इसी में paragraph 35 में.
Para 35.
हाँ.
There is no para 35 in this judgment.
Page number 26 of my writ petition.
Yes. Para number
35.
35. Yes.
Good. Having due regard to the above decision, we are of the opinion that the right of the petitioner to receive pension is property under section under Article 31(1) and by a mere executive order, the state has no power to withhold the same. Similarly, the
This
state
is not an executive order. This is an amendment.
No, this is notification, executive order, not the amendment.
You just see. What is it?
No.
Annexure 4.
In,
You just see Annexure 4, and this is not under challenge. This is not under challenge in this particular writ petition. You just have a look at it.
Because
You read it, please. Read it. Annexure 4, page 90. Padhi.
योजना सभी विभाग अधिसूचना. This is notification. And there is rule and judgment says that
बस एक शब्द पढ़ के चुप हो जाएंगे.
rule के हाँ. This is notification लिखा हुआ अधिसूचना.
पढ़िए. Read it.
भारत का संविधान के अनुच्छेद 309 के परंतु द्वारा प्रदत्त शक्तियों के प्रयोग करते हुए झारखंड के राज्यपाल झारखंड पेंशन नियमावली 2000 में निम्नलिखित संशोधन करते हुए संक्षिप्त सचिव सर झारखंड. So he tried to amend the
आगे
rule.
पढ़िए ना. It is an amendment to the rules. It is an Jharkhand pension संशोधन नियमावली 2018.
This rule can be amended, but through notification, rule cannot be amended. This is held by the Honorable Supreme Court. कि by way of notification.
भैया आप criminal matters ज़्यादा करते हैं, ये सब matter कम करते हैं, इसीलिए आपको नहीं पता. This is not an executive order. This has been issued in exercise of powers under 309 of the Constitution of India. It is not an executive order. What do you mean?
ये तो थोड़ा research करना है.
हाँ, research करिए, बढ़िया से research करिए.
ये सब. Only notification.
ये जो notification है ना, Annexure 4 का, इसको जरा एक कॉपी निकाल के रख लेंगे, ठीक है? The learned counsel for the petitioner seeks adjournment to examine the nature and impact of the Jharkhand of the amendment to Jharkhand Pension Rules 2000 wide Jharkhand Pension within bracket amendment bracket close rules 2018, which has been issued by notification of the state government in exercise of power under Article 309 of the Constitution. Monday को आ जाइए. Post this case on Monday. On Tuesday in the supplementary list. Next Tuesday को supplementary list में डाल दीजिए.
सीरियल 3 में मतलब एक उसमें जजमेंट आ चुका है. रिमांड फैक्टर्स लिखा गया है, जजमेंट ऑर्डर के लिए आ गया है.
तो हम तो कर दिया इन फैक्टर्स.
हाँ, फैक्टर्स कर दिया गया है तो जजमेंट दे देते हैं.
खाली रिकॉर्ड पे लगा दीजिए. सीरियल नंबर ऊपर केस नंबर डाल दीजिए प्लीज. खाली पुट द केस नंबर का नहीं.
Under heading for admission, item 14 WPS 22 of 2023.
order of dismissal, the appeal and revision thereafter. All the three have been dismissed, and we have received each and every order. And check 2, 3, and 4. They have filed a counter affidavit. The pleadings are complete.
You don't need any rejoinder?
No. On this, 2 only legal points are there. The first one is non-service of inquiry report and second show cause, and the second one, this is basically for the unauthorized leave. So the second law point is that whether that leave was a willful one or not.
That is the main. That is the main.
No.
Out of the 2.
Please hold on.
No.
Your inquiry report was not given to him?
No. We have given the reply. We have stated in the counter.
You have denied his statement in the counter
Yes.
affidavit?
We have given the inquiry report.
And
second so-called notice was also served, Lordship. All are on the record.
Lordship, perhaps the statements made in the counter affidavit by the respondents with respect to that statement of mine, that inquiry report and show cause second show cause notice was not given to me, only that can be read. I can, if your leadership permits me, I'll read it. It will be very evident from it that they have not denied it. At para 26.
If there are other statements in the writ petition, in the counter, you file your response to this. They have annexed it, you say so that it was never served on you. It can't be like this, right? If that is so, then under such circumstances, we'll remand the matter from the stage of second show cause. As simple as that.
I'll file one rejoinder.
आप अपना रिकॉर्ड मंगाइए, ढंग से पैरावाइज कमेंट नहीं फाइल करते हैं
नहीं किया
क्या हुआ?
और स्टेटमेंट ऊपर में लिखे हुए preliminary to before giving parallel statement. We have
Which is that paragraph?
26.
Para 26 का reply दिखाइए.
No, sorry. My paragraph is 21. Their reply is at 26.
21 का reply दिखाइए.
26 पे. Page 23.
Para 21 का reply.
May I read you leadership?
Before
Page
that,
number 26. Para number 26.
Para 26 of the counter affidavit.
False and required to be rejected. This is what they have stated in the counter affidavit. The abovements of the petitioner made in para 21 of the petition are false.
Indeed. And leadership can only refer to the entire paragraph.
No, why should we read? Once they say false,
They
means
haven't
false.
annexed. They could have annexed it.
we have
The service. Leadership, the requirement of
annexure K. We can use the annexure K, Lordship. That is the second one.
the service has to be there.
No, Lordship, that annexure K we have annexed. That is the second so-called notice which has been served to the petitioner. We have annexed. We have stated in our
In the
counter that we have.
subsequent-
Acha likhiye. Counsel for the parties are present. Counsel for the petitioner submits that a counter affidavit has been filed in the present case to which he does not want to file any rejoinder. He submits that the pleadings are complete. Post this case under the heading for final disposal on next Tuesday. Okay? The counsels to submit their list of dates and synopsis of arguments by Friday.
Item 15 WPS 49 of 2023.
I have to also file that.
Yes, of course, you should file.
State petitioner pays for payment of their honorarium bills which has not been paid since June 2022. Firstly. Secondly, second payment with regard to regularization of their services. And thirdly, for deciding my representation which has been given by the petitioners to respondent since long back months. What has happened was
Your claim for regularization, where is the question of your regularization? It is a contractual appointment.
yes, notes. Firstly, with regard to payment of honorarium bills.
Okay, why this honorarium has not been paid?
Still,
He's working?
Yes,
Is he working?
They are still working bills. They are not.
Why are you not making payment? Yes, your counter affidavit has been filed.
Yes,
You have not stated anything about payment after May 2022. You pay and then come. You pay up to date remuneration. File an affidavit to that effect. Right? Who will make the payment?
Rural Development Department.
Which respondent number? Respondent number 3 is a responsible
Three.
person, right?
Manrega Commission.
You pay and come. You remit that amount and then come. We'll hear it then. The learned counsel for the petitioner has submitted that a specific statement has been made in paragraph 7 within bracket Roman 5 that petitioner is, how many petitioners are there?
11 bits.
Petitioners have not been paid their honorarium since June 2022. The learned counsel submits that the petitioners are still working.
Yes.
He has also submitted that the respondents are completely silent with respect to the payment of honorarium to the petitioner from June 2022. The learned counsel for the state is directed to seek instructions and file a supplementary counter affidavit in the present case. Instructions from respondent number 3 and file a supplementary counter affidavit. After making payment of admissible dues to the petitioners, and if any amount is found, any portion of the amount is found not admissible, the reasons for the same be also disclosed in the supplementary counter affidavit. Payment करके file करना है, right? Be very very sure of this, right? Pose this case on 16th April 2024 in the supplementary cause list. The affidavit should be filed, the supplementary counter affidavit should be filed latest by 12th of April. इस ऑर्डर को जल्दी से अपलोड कर देना. आप अपना नाम बताएं. आशुतोष
आनंद नंबर 2.
आनंद नंबर 2. JC2.
Mr. Suchendra Prasad, GP4.
Mr. Suchendra Prasad, GP4.
Item 16 WPS.
Let this order be communicated to respondent number 3. Office is directed to communicate this order to respondent number 3.
Item 16 WPS 171 of 2023.
On 22nd, they have filed a reply to the rejoinder that I had filed, Your Ladyship. I had filed a rejoinder in this matter.
Must have inserted new plea.
Yes, Your Ladyship.
Why did you do so?
No, Your Ladyship. They have reiterated most of the contentions that they have made in their counter affidavit itself regarding alternate remedy and everything that they have stated in their.
Why didn't you give them hearing?
Hearing, they never sought for a personal hearing.
There was an order passed by this court to that effect. At that point of time, you never said that if they ask for it, we will give them.
They made a representation after the order
Forget
of this
that.
honorable
There
court.
was an order passed by this court to give them a hearing. Why didn't you give them?
If we have considered their submission in the appeal, personal hearing,
You have considered their representation.
their appeal. Appeal also.
No, whatever it is. You see, it's a matter of dismissal.
It's a matter of
Very serious matter. Capital punishment in terms of economics.
indeed dismissal.
Right? So, when there was an order of the court to give them an opportunity of hearing, why didn't you?
The order was for giving opportunity of hearing.
So?
When we have considered, and they were appellants, when we have considered their grounds of appeal, and the Honorable Supreme Court has repeatedly said that personal hearing cannot be a part of principles.
You should have challenged the order of the writ court. You could have challenged it. You could have sought modification. But once there is an order of the court that you have to give them an opportunity of hearing, then you should have just put a date.
I appreciate
And that is it.
That
You
is
do the needful.
I appreciate.
That should be sufficient.
That should have been done, madam.
So you do it now.
We'll do it now. I had already communicated to the client. Actually, madam, the entire confusion got created because when they represented after the High Court order, they never sought for a personal hearing. They said that our
They will
appeal
not
may
see.
be
Because
decided.
there is already an order passed by this court to give them an opportunity of hearing. Is that so?
Yes, it
The
was.
personal hearing
It
word
is
was
at
not used.
page number
The word personal
279.
hearing was not given.
Then what, whom will you hear?
Ample opportunity of hearing.
The neighbor?
I appreciate, madam. That is
it. Nothing more. You hear them. You hear
Madam,
them.
I have already communicated to the client that.
That hearing was required. Tell me. Gone past now.
Madam, the CMD, Chief Managing Director, is the Appellate Authority. Respondent number was 2. Respondent number 2. Appellate Authority order is at
Respond number 2, CMD.
CMD. Appellate Authority order is at page 298.
298.
Of the writ petition.
Annex
This is
17.
Annex 17, page 298.
Is
298 is the clarification.
Yes.
Subsequent to the appellate authority.
And the other one is Annexure 15. Your
Annexure
Worship.
15 to 80, page 280.
You see, tell your authority that there are many things which may not transpire merely on perusal of records. Isn't it? Hearing is a very important part. अब तो बहुत अच्छा हमको record मिला एक तो order का. We don't need you here.
There was a time frame also. I advised them that why should you not give them a personal hearing? But there was a time frame by this High Court. Therefore, they were in a hurry.
Do the needful. I'll fix a date. You choose your date. कौन सा दिन भेजिए? बताइए.
Well, any time after 2 weeks.
You choose a date. Date, time सब choose करके पूछ के बता दीजिए.
No, I'll wait.
पूछ के बताइए. चलिए pass over कर. Come by 12 o'clock.
Item 17, WPS 375 of 2023.
Yes, petitioner. Yes.
Your Worship, kindly see the 26 February 2024.
Yes.
Time till 14/3/2024 is granted to the respondent number 6 to file counter affidavit in respective case to comply the last order. Reminder, if any, should be filed by 21st of March 2024. Post this matter on 2nd of April 2024. Your Lordships, counter affidavit has been filed. Matter is heard on your Lordship 2nd of February 2023. Whereby Honorable Court has directed to resolve the dispute in local order. They choose not to settle the dispute, your Lordships. Thereafter, counter affidavit has been filed. Later on, matter has been taken on 25th January 2024. Whereby respondent number 6 is directed to file a specific affidavit. And your Lordships has also passed the order to comply the previous order. Till date, no steps have been taken.
So we will decide the case on whatever it is.
Yes, your Lordship.
बात करते हैं?
Similar matter, your Lordships, similar matter file for consideration.
Yes.
May I submit my letter? It could not. The fact is, the affidavit has not been filed. No, my leadership, the DO has changed frequently in that particular district leadership, and I have been following up, and I have been instructed that the case of the petitioner is under consideration, active consideration, in light of the recent orders, similar orders passed by this honorable court.
Similar order. Where is that similar order?
Your Lordship, similar matter, I have annexed in my rejoinder, Your Lordship.
Rejoinder.
Yes, Your Lordship.
This is 21 of 2016. What similar order has been passed? Rejoinder.
Your Lordship, similar, Your Lordship, petitioner on the similar footing. And because the offer letter were not issued by the respondents, Your Lordship, they approached the court. And Honorable Court has directed to issue the letter of appointment, and they have come up before this Honorable Court, Your Lordship, with the offer letter. We have annexed the order of this Honorable Court as well as the letter issued by the respondent, Your Lordship. R2 series, Your Lordship. Rejoinder dated 2nd of November 2023.
What similar order?
Your Lordship.
The case of the
No, just a moment. What similar order are you talking about?
Your Lordship, some of the petitioners, some of the candidates approached this Honorable Court in the similar matter, as because the offer letter was not issued to him, and matter was taken up before this Honorable Court, Your Lordships, whereby they have come up with the appointment letter which I have annexed in my rejoinder, Your Lordship. Kindly have a look at page number 11 of my rejoinder. मेरी भी और लॉजिक विषय स्नातक प्रशिक्षित शिक्षक के पद पर नियुक्ति के उपरांत विद्यालय में योगदान की अनुमति के संबंध।
This is you say that
I have already been selected. My posting was done, but offer letter was not communicated and issued to me. This is the.
so you have given your joining.
No, Your Lordship, because
In those orders they have given the joining.
by virtue of this order they have given the joining.
Which order?
Your Lordship, page
Annexation
number
11.
11. Page number 11 of my rejoinder. उपयुक्त विषय के संबंध में कहना है कि इस कार्यालय के ज्ञापन 48 देवघर दिनांक सचिन सर द्वारा आपकी नियुक्ति उत्क्रमित उच्च विद्यालय सावतर में स्नातक प्रशिक्षित शिक्षक विषय।
Who is the person who will file an affidavit in this case?
DO
We'll call him. We'll call him with his entire office. You tell us. Who is the person who is not responding to your calls?
No, he is responding to our calls.
Then?
Leadership, I was submitting that in recently leadership, there was certain DOs were transferred and posted in the same district leadership. So the counter affidavit could not be filed effectively. The case of the petitioner is under active consideration. For the reasons that DOs were recently transferred and posted, it could not be taken up in the meanwhile. I was just praying that it may be deferred for 2 or 3 weeks leadership, and we will
Your Lordship,
file.
my selection was done in the year 2019.
Which subject?
Your Lordship, history and civics.
History and civics both?
Yes, Your Lordship, both. And my serial number is at 16, Your Lordship.
He was selected, he was informed, he
No.
filled the form online, he appeared online, result was declared online, he participated in counseling through
I have
the
already
information was given
participated,
online.
selected
मेरिट में बोलेंगे ना तो केस डिसमिस कर देंगे.
नहीं, Your Lordship, नहीं.
I'm telling you because there are orders contrary to your whatever you are submitting because everything was done online.
Yes.
But Your Lordship, सब कुछ हम पार्टिसिपेट किए हैं. ऑफर लेटर ये कहते हैं कि कमीशन की वेबसाइट पर होगा. वो जो कमीशन की वेबसाइट पर नहीं है, deoghar.nic.in, Your Lordship, is not the official website of the commission. I was the resident of the state of Bihar, Your Lordship. So I could not afford myself to give this right.
Where have you stated all these
Ah,
facts?
really can. Yes, Your Lordship.
That it was in the website of
हाँ,
Devgar?
लिखा है.
Where is it? Where is
Your
it?
Lordship. इनका इम्प्रूव्ड ऑर्डर
Where is it?
इम्प्रूव्ड ऑर्डर में ही है. कहाँ पे लिखा है?
Annexure 3,
Rejoinder
page
नहीं है.
31. Annexure 3, page 31 में
Who will give you the instructions? You tell us.
DO
Deoghar.
District Education Officer. Deoghar. Respondent number 6.
इसके बाद बोलेंगे इलेक्शन में बिजी। एजुकेशन ऑफिसर एजुकेशन के अलावा सब चीज़ में बिजी रहते हैं। एवरीबडी नोज व्हाट इज हैपनिंग इन स्टेट ऑफ झारखंड। वहाँ से यहाँ तक आने के लिए पिटिशनर से वो क्या क्या हाल बनाएंगे हमको पता नहीं है क्या? वी डोंट नो झारखंड। व्हाट डू यू थिंक? वी डोंट नो व्हाट इज हैपनिंग इन झारखंड एजुकेशन डिपार्टमेंट? Why is he not filing the counter affidavit? How much time do you need?
Just 2 weeks.
Okay. And if he does not file it, then he will appear in person. I will not ask him to appear in person. I'll ask the Secretary Human Resources Department to appear in person to explain his conduct.
Just I stated the fact, Lordship, that the DO were transferred and posted frequently in the recent past, Lordship. And that is why
We'll fix the responsibility on somebody who will compensate him for his losses.
that is
The state will compensate him for his losses. Will you? A teacher is fighting for his appointment letter. What will he teach? The learned counsel for the parties are present in spite of repeated orders passed by this court. The required counter affidavit has not been filed. The learned counsel appearing on behalf of the state has submitted that there has been frequent transfer of district education officer in the district of Deoghar, and therefore the counter affidavit could not be filed. He has also submitted that the case of the petitioner is under active consideration of the respondents. However, by way of last chance, time till April 19th is granted to comply the orders passed by this court. The counter affidavit should also meet the averments made in the rejoinder, which has been filed by the petitioner on 2/11/23. At this, counsel for the respondents has submitted that the counter affidavit will be filed by respondent number 6
Respondent number 6.
or the deputy commissioner.
Respondent number 6 would suffice, Lordship.
Will be filed by the respondent number 6. Pose this case on 23rd April 24 in the supplementary cause list. If the counter affidavit is not filed by 19th April, the respondent number 6 is directed to appear in person on the next date of hearing to explain this court the reasons for not filing counter affidavit.
Item 18 WPS 394 of 2023.
May I please, Your Worship? In this case, petitioner plead for quashing the order dated 6/12/2022, Annexure 7, by which the promotion of the petitioners has been refused. Whereas, as per resolution dated Lordship 24/10/2014, they are entitled for the promotion.
Yes, respondent.
Yes. There are two counter petitions. One is filed by recently by the personal department.
Wherein you have again dismissed his representation. Have you considered this resolution dated 4/4/2014?
Not as per the contract, they have said he is not entitled at all. the promotion. As
Have
per-
you considered the resolution dated 4/4/2014?
There are two resolutions, Lordship. 4/4/2014 and 24/10/2014, where the clause 12 has been amended. And for 24/10/2014, petitioners are absolutely eligible, Lordship.
One is 4/4/2014.
Yes.
Other is?
I have annexed, Lordship.
Yes. Other one is?
Another is 24/10/2014.
Where is 24/10?
Lordship, I am just.
Annexure 3 by
Yes, Lordship.
25.
Annexure 321 is 4th April 2014.
Yes.
And next is, Lordship, Annexure 3/1, page 25, 24 October 2014. Clause 2. This is very
What
important.
is your response to these two circulars?
But, regarding petitioner number 2, Lord, as per the representation filed by the petitioner.
You forget about it. He has annexed these two notifications.
Yes.
What is your stand with respect to these two notifications? With regard to entitlement, how many petitions are there?
Two petitions.
Two petitions. Please, Lord, in first counter affidavit, Lord, please turn page, Lord, 14, annexure B.
Dated, counter affidavit dated 11/23, November 23.
18/9/23.
Yes. 18/9/23, yes. पूर्व पद पर, this is regarding the देवेंद्र नाथ पिंगू, petition number 2. पूर्व पद पर की गई सेवा को वर्तमान सेवाधि के साथ जोड़कर कर सहायक आयुक्त के पद पर प्रोन्नति प्रदान करने के संबंध में प्रसंगत कार्मिक प्रशासन सुधार राजभाषा विभाग झारखंड रांची का संकल्प संख्या 3286 दिनांक 4/4/14 एवं संकल्प संख्या 10483 दिनांक 4/4/14 तथा आपका आवेदन दिनांक 17/1/23। निर्देशन उपयुक्त इस संबंध में कहना कि झारखंड वित्त सेवा अंतर्गत राज्य कर पदाधिकारी के पद पर नियुक्ति के पूर्व आपके द्वारा अन्य सेवा संबंध की गई सेवाधि को वर्तमान सेवाधि के साथ जोड़कर कार्मिक प्रशासन सुधार तथा राजभाषा विभाग झारखंड राज्य के संकल्प संख्या 67 के आलोक में राज्य कर आयुक्त सहायक आयुक्त के पद पर प्रोन्नति प्रदान करने संबंधी आपके अभ्यावेदन पर कार्रवाई के क्रम में कार्मिक प्रशासन सुधार तथा राजभाषा विभाग झारखंड रांची का परामर्श प्राप्त किया गया। कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग झारखंड रांची का परामर्श दिया गया कि संकल्प संख्या 3286 दिनांक 4/4/14 और संकल्प संख्या 67।
It is the repetition of annexure 7. Copy paste.
अलग सेवा संवर्ग बिताई गई अवधि की गणना प्रोन्नति हेतु कालावधि के रूप में नहीं की जा सकती। If he has spent 20 years regular service in the same post and for 1 year in the higher post, then he is entitled. But he has not been. Firstly, he has been appointed in the cooperative department. Thereafter, he has been appointed in this category. That's why he is not entitled.
So he has not completed the requisite qualification as per this circular.
Yes. And that has been also filed by the.
Is it a fresh appointment?
No.
Is this a fresh appointment?
As per my understanding, I say
As per the understanding of the state and the notification. आप अपने understanding.
It may be a fresh appointment. Otherwise,
we do not know. Where is your appointment letter?
Lordship, I have annexed.
Where is it?
Annexure 1. Annexure 1. Regarding Lordship petitioner number 1.
Okay. What is the
I have
date
given
of
a
appointment?
typed copy, page 13, serial number 3.
Okay.
Appointed in the year of 1995, Lordship.
In the cooperative department?
Yes, Lordship.
And then, how did you get posted in the this?
Lordship, in this, as per resolution,
20 years continuous service in the state government. They are interpreting.
Where is Annexure 2? Annexure 2 is what?
Annexure 2 is the appointment letter of the petitioner number 2.
Again in the cooperative department.
यहाँ पर दिया है बक्सर संप्रवर पदाधिकारी बक्सर नवागढ़ प्रधान 13/11/95.
Under which department?
Cooperative department.
Cooperative department.
Yes, Lord.
And now you are working under which department?
I am working since 2018 as a state tax officer.
Where is that your appointment or transfer or your posting or whatever?
That
How did you get shifted from cooperative department to the state tax department?
That Lordship
Where is that letter?
Stated in Lordship.
Statement से नहीं होगा ना? Proper document चाहिए.
They are not denying that we are in that particular post.
They are saying that in that particular post you have not completed 20 years. You
Yes.
might have completed 20 years in cooperative department.
20 years continuous service from the date of appointment to and 1 year service in the said particular year. Lordship may kindly see annexure 3/1 may kindly see page 25 what resolution has stated. If you had your Lordship got उक्त संकल्प की कंडिका 2 का निम्नवत रूप से संशोधित करने का निर्णय लिया गया। संकल्प संख्या 3286 दिनांक 4 अप्रैल 2014 की कंडिका संख्या 2 विद इन ब्रैकेट रोमन 2 के पश्चात एक नई उपकंडिका 2 रोमन 3 जोड़ने का निर्णय निम्न रूपे ने लिया गया। नौ लॉर्डशिप उपयुक्त प्रावधान के पश्चात भी पद रिक्त रहने की स्थिति में सरकारी सेवा में 20 वर्ष की सेवा पूर्ण करने तथा धारित पद पर एक मिनट हमको बोलने दीजिए। धारित पद पर 1 वर्ष की सेवा व्यतीत करने वाले पदाधिकारी की उच्च रिक्त पदों की प्रोन्नति कालावधि के कारण बाधित नहीं होगी। What they are interpreting? It is their resolution, Lordship. 20 वर्ष धारित पद पर सरकारी सेवा में 20 वर्षों की सेवा पूर्ण करने तथा धारित पद पर 1 वर्ष. I am in 5 years in that post. And now they are refusing, they are not accepting their resolutions. On the basis of this, Lordship, the judgment by this division bench
तो आपका contrary to your own circular?
Yes.
Lord,
How do you justify this?
Lord, again I am
Yes,
reading.
you are there in this list.
Again, our case is that serial number 15. Serial number 50. This is with respect to planning department. The issue is, my lord, that should be read in the whole, my lord. The cadre here, these persons are changed. They change into a different cadre. They were appointed freshly by virtue of promotion, my lord.
Who have done it? Who has done it? State government.
State has done it. They are
in continuity of service.
Continuity in service. They are entering into a different cadre, my lord.
So,
for promotions, my lord.
Does this circular say that he should be in the same cadre for 20 years?
My lords, if we read the entire circular from the starting heading.
Serial number 15 के साथ इसको take up करें. Identical circumstances.
My lords, same circular, my lord.
लिखा है
serial number 15
serial 15 में order हो चुका है.
50 my lords.
हो चुका है क्या?
50.
We'll see that. We have to interpret this circular. We can't leave it open to you.
Even in general thing also, my lords, it has helped in respect to promotions, my lord. Cadre should be the unit, my lords, for considering the service and everything. Here they have entered into a different service, my lords. different.
At their own volition, or you changed it?
No, because of they have selected through departmental examination or by virtue of promotion, they were given. And if you see the first two exceptions, my lords, they should be considered. They should complete the entire time period, my lords, either in the present post or along with the second one. In both the exceptions, they should have 3 years minimum, my lords.
Just a moment.
And only in the third exception, it is 1 year, my lords.
But Lordship, that the resolution does not speak like this, Lordship. It is absolutely clear. 20 years continuous service and present post 1 year.
For the present post, my lords, the probation period itself is 2 years, my lords.
How then you have a resolution has says 1 year? Then how resolution says 1 year?
Unless
they are contradicting their own resolution, Lordship.
जो ज्यादा जोर से बोलता है ना, हमको लगता है उसका केस बहुत खराब है, इसलिए शांति से बोलिए, कोई जरूरत
नहीं, कभी-कभी एक्साइटमेंट में लॉर्डशिप,
कुछ ऐसे एक्साइटमेंट की जरूरत नहीं, we will hear you, right?
It is highly probable, Lordship.
We'll see that. They have one argument, maybe correct, incorrect,
Lordship.
right?
It is.
So that is their perspective. So we have to examine.
It is up to Lordship to.
No. It's not like this. We will hear you. I'm just trying to understand. The document is in Hindi. I'm trying to translate it also simultaneously. So we'll take it up with serial number 50, right?
Or any other date, Lordship.
I'll put it on some other date, and I will get this document. You have English translation to this?
With respect to 3 exceptions, I have translated.
We'll get it. You just give that translation. We'll get the entire document translated. हमारे तो यहाँ translator है ना? ये document translate करें. This would be annexure 3 and 3/1.
Yes.
Only these two should be sufficient?
Yes.
Or you want anything else to be translated? These two should be sufficient? This is notification dated 4th April 2014 and notification dated 24th October 2014. These should be sufficient? Serial number 50 का case number बताएं?
2008-23. 2008-23.
This is with respect to that amended clause, translation.
There is in their case there is an order of rejection. In your record there is no order of rejection. They are just seeking a mandamus.
But there is no order of rejection. They are praying for the promotion in view of those two.
But both the issues are the same.
Yes, same circular, same.
The learned counsel for the parties are present. You inform Mr. Rahul Kumar also. It is reported at bar that similar issue is involved in WPS number 2008 of 2023, which relate to interpretation of the two notifications which are dated 4th April 2014 within bracket annexure 3 and 24/10/2014 within bracket annexure 3/1. In the present case, the claim of the petitioner has been rejected by the impugned order. However, in the connected case being WPS, in another case being WPS number 2008 of 2023, only a writ of mandamus has been sought for. Since the issue involved in both the writ petitions are same, let these matters be tacked. Post this case on next Tuesday. ये दोनों डॉक्यूमेंट जरा ट्रांसलेशन के लिए मंडे को I will, you can have a look at the translated copy. Whatever translation we have, you can match it.
On 9th it.
ठीक है इसको ना मंडे को लाकर you give your appearances in all the cases. Mr. राहुल कुमार आए हैं कोर्ट में उनका appearance दे देंगे अगर वो आएंगे तो उनका appearance हम दे देंगे इन चारों का नाम नोट कर लीजिए जो ट्रांसलेटेड कॉपी होगी तो इनको सर्कुलेट कर you give your names.
Pass over case item 7 WPS 988 of 2023.
Yes.
Please pass over it for after few cases in this week.
Pass over case item 16 WPS 171 of 2023.
Any date?
They are requesting that it will be on any day in the week commencing 15th April. And I have told them to arrange for a virtual hearing also because Appellate authority is in Bombay. Okay. The petitioner is in difficulty to travel to Bombay because he is based out of Ranchi. They will give a virtual hearing also.
Okay. Post 15th of April?
Week commencing 15th of April, on any day.
60?
Your Honor, my client has asked for 19th April.
19?
Let it be week commencing 15th of April. We'll inform them in advance.
कुछ information नहीं होगा आप बताइए 19th क्या दिक्कत है week commencing?
I have told them they are under difficulty because of the election duties. They are not certain on 19th because this now will.
You have your mail ID?
They'll inform us. We'll give them 4 days notice in advance.
Okay.
It will be in the week commencing 15th April on any day. We'll give them 4 days notice in advance. And we'll give them virtual hearing also. That option is available. There is only one request, Madam. When the appellate authority had passed the order, that time the difficulty was that the disciplinary authority was a part of the committee of functional directors. That is why the appeal had not gone to the committee of functional directors because he was himself the judge. Therefore, the appeal was given to the CMD to decide. But now, the committee of functional directors can decide the appeal because the disciplinary authority who had originally decided can be kept away and the remaining functional directors can decide it. So, if my lords are remanding
No, once you have already taken a call
Malus.
that the matter was to be decided by CMD, because the disciplinary authority was a part of the functional directors, the situation has not changed.
It has changed, I'll give the reason. There are 4 functional directors, marketing, finance and 2 more members. The person who had decided their disciplinary authority order was the director finance. So therefore it had not gone to the functional authority, and the other reason was that the other 3 directors were not there. So he was the only one. Therefore the company decided that it should not go to him, it should go to the CMD.
So let it go to the CMD. We are not going to enter into this. CMD is the best person.
He is the best person, but actually I have got the rules. Their rules says so.
You have yourself taken a call, so therefore it should go. We don't want to enter it. Only a very short order. That there was an order of this court to give them personal hearing, and you say that he has not asked for it, so this is not proper, and that is it. And ask him to decide with an open mind.
Indeed.
WPS number 171 of 2023. The Learned Counsel for the parties Appellate. This petition has been filed for the following relief. The Learned Counsel for the petitioner has submitted that the writ petition can be disposed of on a short point inasmuch as no opportunity of hearing was given to the petitioner in spite of order dated 26/7/2022 passed in WPS number 2100 of 2022. She submits that the aforesaid writ petition was filed by stating that the petitioner had preferred the departmental appeal, but the same remained pending, and as such a direction was prayed for to dispose of the appeal expeditiously. She submits that after hearing the counsel for the parties, a direction was issued to the respondent number 2, within bracket Director Finance, comma, Hindustan Petroleum Corporation Limited, bracket close, to dispose of the appeal preferred by the petitioner after giving him ample opportunity of hearing within a period of 6 weeks from the date of receipt/production of a copy of the order. The learned counsel submits that in spite of specific direction to give an opportunity of hearing, no opportunity of hearing was given, and appellate order has been passed against the petitioner. She has also submitted that on account of not granting opportunity of hearing, serious prejudice has been caused to the petitioner, and many points which the petitioner would have canvassed during hearing has not been considered. Okay? The learned counsel appearing on behalf of the respondents has submitted that the action of the respondents is bona fide inasmuch as, in terms of the rules, the question of personal hearing arises only when the employee demands such hearing, and therefore no opportunity of personal hearing has been granted. He has submitted that other materials have been taken into consideration while deciding the appeal. He has also submitted that the appeal has been decided by the chairman cum managing director of the respondent in view of the fact that at the relevant point of time, the disciplinary authority was a member of the committee of functional director. That should be enough.
He was the only member. The other
He was the only available member of the committee of functional director, and the appellate authority as per the rules is बस इतना ही लिखा होगा.
Only one thing, the petitioner never sought for personal hearing.
I've said so. The learned counsel submits that since the petitioner never sought for personal hearing, therefore no personal hearing was given. Without prejudice to the aforesaid submissions, the learned counsel for the respondents has submitted that in case this court is inclined to set aside the appellate order on this short ground, then personal hearing can be granted to the petitioner in the week commencing 19th of April.
15th of April.
In the week commencing 15th of April 2024, he has submitted that if the petitioner so requires, virtual hearing can also be granted to him. He has also submitted that the petitioner may also file written submissions, right, in support of his, along with the personal hearing. Written submissions में क्या होता है कि you put something which is not there on record. That creates a problem. Okay. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that at the stage when the appeal was pending, the petitioner had moved this court in WPS number 2100 of 2022, and following order was passed. इसको quote करिएगा page 279 and Annexure 14. Upon perusal of the said order, it is clear that a direction was issued to decide to dispose of the appeal after giving ample opportunity of hearing to the petitioner. This court is of the considered view that once a specific direction was issued by this court to give an opportunity of hearing, there was no further need for the petitioner to again pray for opportunity of hearing, and the authority dealing with the appeal ought to have given an opportunity of hearing to the petitioner. In such circumstances, it is an admitted fact that no opportunity of hearing has been given to the petitioner while deciding the appeal by the respondent number 2. On the aforesaid short point, this court is of the considered view that the impugned order passed by the appellate authority calls for interference, so that calls for interference and is required to be set aside, so that a fresh order be passed by respondent number 2 after giving an opportunity of hearing to the petitioner. It is, however, it is further observed that this court has not pronounced anything with regard to the merit or otherwise of the plea raised by the petitioner before the appellate authority. Accordingly, the impugned order passed by the appellate authority dated
2022 and 21/9/2022. The clarification was on 21/9/2022.
Impugned order dated 23/8/2022 within bracket annexure 15, as well as the clarificatory order dated 21/9/2022 within bracket annexure 17, both passed by respondent number 2, is hereby set aside, and the matter is remitted back to respondent number 2 for passing fresh order after giving an opportunity of hearing to the petitioner. The petitioner be issued notice through email fixing at least 4 days in advance, fixing date and time of hearing, and in response, the petitioner may choose physical hearing or virtual hearing. The fresh order be passed by the appellate authority. In terms of this order, within a period of 6 weeks.
After the closure of personal hearing.
After the
closure of personal hearing. 30 days after the closure of personal hearing.
6 weeks फिर ये टाइम मांगने लग जाएंगे, फिर आप लोग का मैच नहीं करेगा, फिर आप कहीं छुट्टी पे चले जाइए।
ठीक है, मान लो 6 weeks में।
ठीक है।
मान लो
फिर ऐसा होता है।
ये होता है। This happens.
Within a period of 6 weeks. From the date of communication of this order. The learned counsel for the respondents is directed to immediately communicate this order to respondent. आप अपना mail ID दीजिए. You provide it right away. The counsel for the petitioner has provided the mail ID of the petitioner. Disposed of.
Item 19, WPS 423 of 2023.
This matter pertains to promotion matter. I was appointed as a junior engineer in the year 1988, my lords. And presently I retired, my lord, with effect from 30th January 2023. Now, first of all, my lord, they appointed me on the post of junior engineer and promoted me as in charge assistant engineer. My lords may kindly see page 49.
No,
Annex
this
7.
promotion matters cannot be decided without list of dates.
Not my lords.
Without list of dates. That will be required.
If I will give details and list of dates.
Pleadings are complete?
Yes.
What is your stand?
It is not entitled for the sentence.
That is the usual standard.
Any specific ground? He has not completed the period or any disciplinary proceeding against him?
AMI degree related, promotion related to AMI degree.
Okay. He wants from? He wants a promotion from?
From assistant, junior engineer to assistant engineer.
Assistant engineer. So AIME degree does not have promotional avenues? Yes or no? There are roster points with regard to AIME degree and other direct recruits of executive engineer or assistant engineer, isn't it? Yes or no? They merge in one cadre, do they? I don't know.
Promotion has been granted in the year 20 already. 2020.
2020.
That is final.
Why not granted prior to that date? When did he become eligible for promotion? According to you, when did he become eligible for promotion? You have granted or you have not granted?
Granted promotion in the year 2020, he is eligible on that day.
Okay. Have you stated so that he became eligible in the year 2020 itself?
Eligibility is not mentioned, but promotion is granted in the year 2020.
To the post he is claiming in this writ petition?
Yes. Assistant.
You are seeking promotion from an anterior date?
My
What is the date you are claiming
Yes,
from?
my lord, the date is 36/2008, my lord. Notional promotion. 30th of June 2008. Prior to that, my lord, I got the degree of Associate Member of Institution of Engineering, AMIE, my lords. Now, my lords, there are 3 resolutions, 2 resolutions of the state of Bihar and 1 resolution of the state of Jharkhand. 1 resolution of the state of Bihar and 2 resolutions of state of Jharkhand. In all the resolutions, certain quota has been, my lord, provided for 3 streams. The post of A, my lord, cadre of A is filled up by 3 streams. 62% by way of direct appointment from commission, my lords, 62%. 10% from AMIE quota, my lords, and 28% from diploma holders, my lord, junior engineer. So they made me in charge assistant engineer in the year 2008 itself, my lord, consequent upon my representation, etc. And they waited for 12 long years. I worked as in charge, and in 2020, my lord, they granted me regular promotion. That is also, my lord, in the teeth of these resolutions, which are having a sort of a statutory force. I cannot say 309 proviso, but it is being adopted, my lord, by both the states, my lord. Because I ought to have been promoted from the 10% AIME quota,
That's
but
right.
they are totally mum.
So there was vacancy from 10% AIME quota? AMIE quota? There was vacancy?
I would be candid in this regard, that vacancy is always under their custody. But so far,
you
yes.
have to bring the
My
roster
lords.
points.
Very
Without that, it cannot be decided.
Yes, very good.
The learned counsel for the parties are present. the counsel for the petitioner has submitted that the petitioner, one petitioner,
Only one. So
one petitioner is entitled, that the petitioner was entitled for promotion with effect from 30/9/2008.
30th June month.
Sorry,
6.
30/6/2008
Month.
to the post of Assistant Engineer Civil
From AIME quota.
from
ME quota.
AIME quota.
That is, my lord, associate member of institution of
That's right.
10
He has, which constituted 10%
months.
of the total cadre post.
As per the resolutions, if my lord wants. I
Total
can-
cadre post,
Yes, cadre.
cadre post as per the resolution issued by the respondents from time to time. He submits that the promotion has been given only in the year 2020, but it ought to have been granted with effect from 30/6/2008
Under that particular quota marks.
under the aforesaid quota, inasmuch as the petitioner was already discharging his duty of in-charge assistant engineer civil in the pay scale of junior engineer with the bracket civil with effect from 30/6/2000.
Months.
However, he is not aware regarding the vacancy position with respect to 10% AIME quota as on 30/6/2008, nor the same has been disclosed by the respondents in the counter affidavit. Have you disclosed it?
No.
The learned counsel for the respondents is directed to file a supplementary counter affidavit with respect to the submissions made by the petitioner as recorded above. आप लेके आइए roster point, right?
That is the crux, my lord. My lord will very correctly appreciated. That is the crux. From when the vacancy. And in the meantime, we'll providing list of dates.
Just a
moment.
But petitioner is never challenged the notification dated 36.
They will not challenge it. If there was 10% AIMI quota, if there was vacancy, then only there is a question of his promotion. Otherwise, there will be no question of his promotion. And then if there was vacancy, then we will see whether retrospective promotion can be granted or not. That is a separate thing. Whether it is a financial upgradation or it is a regular promotion, these things, because as per our service code, unless you join the promotional post, you are not entitled to the benefit of the promotional post, unless it is a financial upgradation. We do not know how the things are going to work. If there was no vacancy, matter ends, full stop.
Yes.
How much time will you need? You file a proper affidavit.
3 weeks.
Who will file it? Respondent number 2. Right?
Point number 2.
Let the supplementary counter affidavit be filed by respondent number 2 by 30th of April. Post on 7th of May. Rejoinder, if any, by 3rd, by 6th, by 6th May.
Yes.
Rejoinder, if any, by 6th May. Post on 7th of May.
Item 20 WBS 424 of 2023.
This is application regarding payment of 6th and 7th pay revision in the Minority College, Lord Jamshedpur. Initially, the government of Jharkhand and government of India has also notified that 6th and 7th pay revision shall be applicable to everybody, those who are getting pension. But subsequently, the notification after sometimes after few months it has been changed. And Annexure 5, page number 99, इसमें लिख दिया गया कि घटानुदान अल्पसंख्यक महाविद्यालयों को छोड़कर exception has been made, page number 99. Before this notification, there were two notifications, one by Government of India and another by Government of Jharkhand, both accepting that everybody shall be given the up-to-date promotion up to 7th pay division. In the pension matter,
Counter affidavit has been filed.
My lord, it's page number 99, it is a government order.
Annexure 5.
Annexure 5, that's important, in which the word is घाटा अनुदानित अल्पसंख्यक महाविद्यालयों को छोड़कर. It is the state's policy decision. Once the state takes a decision, we will be paying. The state will give us money and pass it on to them. We are not objecting. Let the state take a decision.
State must be a party here.
Yes, it is a party. Let the state fight.
How do you make a distinction between teachers of minority school and teachers of
teachers of minority aided college? A fund is being issued to those minority aided institution and lordship. Out of that fund, they are being paid. The teachers.
The fund which is quantified is based on the salary to be paid.
Yes, lordship.
Right?
Yes, lordship.
It is based on the salary to be paid.
Yes.
Then how do you distinguish a minority institution with respect for it? It is one thing to say that you do not sanction any post. There is no problem. But once you sanction a post, how do you make this kind of discrimination? With regard to schools, I have decided this issue.
those who retired after 12, they are getting 7th pay. And those before December 2012, they are not being given.
You have retired before December 2012?
Before December 2012.
So
they are not being given. Moreover,
the corresponding teachers in other regular colleges are getting this benefit?
Moreover, my lord, I am coming to this, my lord. Moreover, my lord, actually,
You have filed your counter?
Lordship,
they have completely ignored this paragraph. They have not replied.
अभी डिसाइड तो नहीं कर रहे ना, काउंटर नहीं आया, आपके पक्ष में बोल रहे हैं, इसीलिए आप शांत रहिए.
इन्होंने रिप्लाई नहीं दिया, उस इश्यू को रिप्लाई नहीं दिया, बाकी उन्होंने कह दिया कि ये
रिप्लाई नहीं है इसलिए नहीं दिया.
We will file.
I will also pray a copy of the state's counter to be given to me also. Because I will know what
You cannot make a discrimination
अभी
vis-a-vis
तो आया
minorities.
स्टैंड
सर आप चुप नहीं रहते.
नहीं
प्लीज
उन्होंने कह दिया एक्टिव कंसिडरेशन में है, दो तीन एफिडेविट में कह दिया सिमिलर एक एफिडेविट हम लाए.
तो एक्टिव कंसिडरेशन में है तो जाने दीजिए, फिर एक्टिव कंसिडरेशन होने दीजिए.
नहीं तो हमारा ये कहना है कि ये
petition is premature. How much time will you take to decide if it is under active consideration?
Lordship, I will go through the case, Lordship.
कहाँ लिखे एक्टिव कंसिडरेशन?
ये दूसरे सिमिलर केस में 3 4 5 केस के
सिमिलर केस में पहुंच. आप इस केस में बताइए, लिखे हैं एक्टिव कंसिडरेशन?
दूसरे केस
कौन सा केस है बताइए? विच केस? रिट नंबर? स्कूल के केस में हम लोगों ने डिसाइड किया. यू आर नॉट अवेयर. With respect to school, I think I have only decided Mr. A.K. Das was appearing for minority institution.
In this case, the state should take a conscious policy decision. They should also give me a copy of
No,
the
they cannot. They have to take a policy decision in favor of these petitioners because they cannot make any discrimination. Once they sanction the post, under such circumstances, they are bound to give them all the benefits.
Yes.
They cannot, otherwise the quality of education in these institutions will be in under cloud. It should automatically apply to them. किस writ petition में?
एक्चुअली
पता ही नहीं.
हमने रखा दूसरे फाइल में क्या रखा गया है वो. Moreover, my lord, actually beginning when the pension was allowed, the main case which has been decided, I have annexed the order of this before this of the order of this page number 62. In this case, my lord, analogous cases, 6 cases were decided, and everything has been said. And finally, concluding part is that at par with the other teachers, collegium shall be issued, and everybody shall get.
The learned counsel for the parties are present. State has not filed counter, no?
We have filed counter affidavit, Lordship. But we have given our reply that we are giving 7th pay revision with effect from 1/4/2021 to the university teachers, Lordship, retired university teachers. Not with respect to minority constituency issues.
That's the whole case. That is the whole case.
But
That
the
is
reply of the
what-
paragraph prayer has not been given. Not any statement in this regard has been given by
I will file a
the
specific
state government.
counter affidavit.
It is not the case of a university, it is the case between the employee and the government.
No, I am not saying, I am only praying.
Government shall pay to the university, the university shall give to us. Otherwise, we will not able
Sir,
not
I am
getting.
only asking for a copy of the counter affidavit so that I know what is the stand of the state. That is all.
I have a next one judgment of the Supreme Court and another judgment I will having in my hand. In this case also, it has been decided. Equally, they would be given. My lord, before the order
learned
is passed,
counsel for the parties are
one thing, my lord,
present.
before the order is passed, one my.
Sir,
one-
हम adjourn कर रहे हैं.
one has died. My lord, out of some person. My lord, the respondent petition number 3 has died. So I have filed IA 2697 to substitute.
Substitute whom?
To substitute his son. Sorry, his daughter Kiran Mishra. Paragraph 8.
There is no other legal here. Wife is not there.
Recently I have filed, thereafter it was for the first time it has been taken. This IA 2697.
You see, have expired on this and left behind two daughters and
11
two daughters, one son and a wife.
11/3/2024 I have filed.
Sorry?
Anyway, even it is not substituted, does not affect because the everybody when they will get, they will get everybody.
Substitution तो करना ना होगा सर. आप कैसे बोलते हैं?
The wife, actually wife is the dependent.
So, where is the wife?
Wife has not solved the affidavit, but the
No,
wife
no,
is.
she should. You give the details. If you do not.
Paragraph 5, Kalavati Devi is the wife who shall be given. Page number, paragraph 5 of the petition that I gave. She is entitled for family pension.
You file wakalatnama of only this.
Yes, Wakalatnama I have filed.
No, you file for others also or give the details. We'll issue them notice. We do not. ऐसे नहीं होगा ना? It can't be. You file supplementary affidavit. I said this is not the way in which the substitution can be allowed.
Correction बाद में file कर देंगे.
You file. पहले लिखिए I counsel for the parties are present. IA number 2697 of 2024. Counsel for the petitioner has submitted that petition number 2 has expired during the pendency of this case. The substitution petition has been filed only by one of his daughters, namely Kiran Mishra. डॉक्टर नहीं है, त्रिभुवन झा की डॉक्टर है, वाइफ का नाम नहीं है इसमें. However, from the perusal of the interlocutory application, it is apparent that petition number 3 has expired, leaving behind his two daughters, one son and a wife. Counsel for the petitioner prays for time to file appropriate affidavit and also wakalatnama on behalf of other legal heirs of petitioner number 2. This is petitioner number 3. Let the supplementary affidavit be filed by 23rd of April 2024. The learned counsel appearing on behalf of the petitioner with regard to the writ petition has submitted that the respondents are discriminating between the teachers of minority institution whose salary is who were working under sanctioned post and salary was being paid by the state government, vis-a-vis those teachers who were working in the colleges maintained by the university,
State government.
maintained by the state government. The learned counsel submits that such discrimination is not permissible in law, and he submits that the issue has already been decided by this court in batch of writ petition being WPS number 1654 of 2013 and other analogous cases by judgment dated 12/8/2016. He submits that the said judgment has attained finality . He has submitted that although a counter affidavit has been filed by the state, but this aspect of the matter has not been dealt with. Correct?
Not at all.
The learned counsel for the state of Jharkhand is directed to seek instruction and file a supplementary counter affidavit with regard to the aforesaid submissions made by the learned counsel for the petitioner. Respondent number 4 will file the affidavit, or 3, principal secretary or director.
Normally directors deals these cases.
Respondent number 4.
3 or 4, it's a matter of policy, therefore 3 should file it. Right?
Yes.
Let the supplementary,
Respondent number 3.
let the supplementary counter affidavit be filed by respondent number 3. By 2nd of May?
Yes.
By 2nd of May. Post on 6th of May.
Item 21 WPS 426 of 2023.
Yes, petitioner.
But the case is that rupees 60,000 was deducted from my account on the name of income tax in the year 2011 as I was a government servant, but the same has not been deposited.
Not
The income
credited in your
tax
account?
Yes. The
Yes.
same has not been deposited, and 2017 the notice has been given to me by income tax department, and after fine, including fine, I have paid the same. So I am paying the fine amount and rupees 16,000 with interest from year 2011.
Is it the counter affidavit?
Yes.
My lord, this
You did
case,
not credit the amount to the income tax department.
we have credited the amount against TDS for the financial year 11 and 12. It was deposited to the income tax. The 16,000 rupee has shown unconsumed. it is not that the amount was deducted and
What
not.
is unconsumed?
There was some error, some clerical error in.
Who said unconsumed? The department,
I have
income tax
annexed the
department.
document, income tax document I have annexed. Lordship may kindly see para 8 of the counter affidavit filed by respondent number 4 as the managing director of the corporation. 2-3 paragraphs and annex are also. Para 8, your Lordship. The petitioner was working on deputation from the irrigation department, government of Jharkhand. The petitioner was posted as junior engineer in the Jharkhand Police Housing Corporation Limited.
Readings are complete, I suppose.
Yes.
Yes.
With effect from 1/8/2006 to 11/2/2014. Next paragraph. It is stated and submitted that is posting in the Jharkhand Police Housing Corporation Limited, an amount of rupees 72,199 was deducted from the income of the petitioner against TDS. But at the time of TDS return filing by the corporation, challan of rupees 56,199 only could be consumed. However, deduction of rupees 16,000 was made from area of salary of the petitioner, but the same has not been shown as unconsumed challan.
The same has been shown.
Shown as unconsumed challan, reflecting in the tax portal of the income tax department, and the same could not be tagged with his PAN due to clerical error.
So who will suffer for that?
But
if you do not tag it with his PAN, then he will not get a credit.
Yes, but
Then-
subsequently, revised, the TDS of the petitioner has been deposited.
When?
21 actually.
Yes.
After filing of the case.
It is in January 23.
So he has suffered. You know, there is a prosecution if you do not deposit the TDS properly with the income tax department.
Yes, but the properly
You
not,
want prosecutions?
but the challan number, everything is there. I have annexed.
Very
annexed
good.
it.
It is there, so what? When you deduct the amount, it is your responsibility to ensure that it is properly credited in their account. They have nothing to do. If you do not give the PAN number, it will go to a suspense account. Certainly it will go to a suspense account or whatever. But he has paid this amount. A demand was raised by the income tax department and he has paid this amount with interest. You reimburse it. You are bound to reimburse it. वो तो इनकम टैक्स को पार्टी नहीं बनाए ना, पार्टी बनाते तो प्रोसिक्यूशन कर देते अभी आप. Where is the income tax department? There is a prosecution for this, for not crediting the TDS property. There is a prosecution for this. Are you aware?
Yes, but
तो इसीलिए पैसा दे के शांति रखी.
तो पैसा तो इनका फिर रिवाइज रिटर्न भेज दिए.
रिवाइज रिटर्न तो भेज दिए, उससे क्या होगा? आप रिटर्न भेज दिए, लेकिन अब तो वो फाइनेंशियल ईयर का असेसमेंट नहीं खुलेगा ना. हाउ विल यू गेट दैट अमाउंट? Find it out somewhere. Where is the income tax department? Who is appearing for the income tax department?
Respondent number 6.
और ये सैलरी मैटर है कि टैक्स मैटर? सिंगल बेंच में कैसे? सैलरी मैटर नहीं है, टैक्स मैटर है.
सर्विस मैटर से रिलेटेड.
नो.
क्योंकि सर्विस में के दौरान ही डिडक्शन.
No. This is essentially a tax matter. Where is the income tax department? It is not a salary matter.
Page 15 of the Miller counter.
Where is the income tax department? Serve किए हैं हमको?
Yes, copy.
Who appears for income tax department? किसको सर्व कर दिए हैं? State of Jharkhand. Where is the receipt of income tax department? नाम अपीयर कर रहा है किसी इनकम टैक्स डिपार्टमेंट का?
नाम appear नहीं.
Nobody's name is, he has not served it in fact.
But the defect has not been pointed, the copy has not been served.
अब हम लोग को डिफेक्ट पॉइंट आउट करना पड़ेगा ना, क्योंकि ऑफिस तो कुछ
That is
करता
why
नहीं है
I
और
was-
आप लोग को कोई मतलब नहीं
That
है.
is why I was under impression that the copy has been served.
Call Mr. Rahul Lamba, he appears for the department. There is one more person, क्या नाम है? चाहिए एक नंबर कोड पे 2 नंबर कोड. नहीं, एक और है नए पैनल में है इनकम. हाँ, उनको बुला के लेके. कॉल इन. उनका नाम जरा फ्लैश कर. 2:15 बजे आएगी. उपाय कुछ करेंगे, लेकिन हो सकता है डीपी में हमको भेजना, बिकॉज इट इज एसेंशियली अ मैटर रिलेटिंग टू इनकम टैक्स.
जो इनकम टैक्स पोर्टल है उसमें नेक्स्ट ये दैट शोज दैट कि 2 फरवरी 2012 में ही चालान से 16,000 भेज दिया गया था. बट द पिटिशनर मतलब हैड नॉट प्रोड्यूस एनी नोटिस. द नोटिस बट certainly served. He had first time approached before the authority in 2020.
It is
Thereafter,
essentially a matter of division bench, not of this court. Single bench का order नहीं. लिखिए तो पहले उनको मिस्टर रत्नेश को आने दीजिए.
250.
हाँ 215.
Item 22 WPS 427 of 2023.
Petitioner.
Lordship, I came for 1 week time to file the rejoinder. As the rejoinder is already drafted, but the petitioner filed the actual rejoinder.
Counsel for the parties are present.
Already time was granted, Your Lordship.
Sorry?
As per the last order, already time was granted to the petitioner to file the rejoinder.
Lordship, the petitioner wife is in a native village, so she couldn't.
Counsel for the petitioner prays for
This
and
is
is
a matter which should go to division bench because he has challenged the virus of the Jharkhand State Unaided Educational Institutional Grant Act 2004. May I point out that he says that the provisions of Jharkhand State Unaided, it is in page number 8.
Where is the prayer? Page number 8.
Page number 3. He asked for quashing of the provision which has been relied upon in view of the provisions contained in Jharkhand State Unaided Act 2004, and it is more clear at page number 8, subclause 5. I will just point out to this honorable.
Let him, because there is no clear prayer, let him file his rejoinder, you just park it. If we go through the records, we'll refer it
I will
to.
just say it is an affiliated college. He says it should be fully aided, like all colleges, full salary be given against the provisions as contained in this act. That's his prayer. So
He is not challenging that or.
No, I just wanted to bring it to the notice of the
The
honorable.
learned counsel for the parties are present. The learned counsel for the petitioner prays for and is granted time till 16th of April 2022 to file a rejoinder to the counter affidavit by way of last indulgence. Pose this case on 23rd April.
Item 23 WPS 446 of 2023.
Adjournment in this case for file a rejoinder to the counter affidavit. Lastly, we have taken
Same
the.
order. Last chance नहीं हुआ ना अभी तक.
नहीं, last chance नहीं.
By way of last chance.
Item 24 WPS 582 of 2023 along with item 25 to 42.
Yes, petitioner. Who's for the petition?
some candidate of this examination of the Supreme Court.
So,
Supreme Court passed some order, which is not on 22nd of March.
what order has been passed?
Right now, it has been not in website or not in a project.
What is the nature of order no ID?
The court has especially said if they will not interfere in the or judgment given passed in the Supreme Court, they will not interfere. And if anything has this is oral order.
No, बताइए.
They can everyone who have grievances they can approach to the High Court. I am इसलिए वो senior appellate told that take a judgment today and that after the coming of the order it will better to
SLP number है?
डायरी नंबर
डायरी नंबर बताइए.
3737 पब्लिक
Sorry.
30
हिंदी में बोलिए, इंग्लिश में बोलिए, मिक्स करके बोलिए.
30
30
30737
737 of 20 4 की 23 23
This is diary number.
One small submission with regards to item number 24. What is the prayer in that particular writ petition that is different from the other prayer, perhaps?
निकाल के अलग कर दीजिए. उनको आपको adjournment नहीं चाहिए ना?
We may assist the court.
We will segregate it. You argue the case. Where is the problem? निकालिए 37.
But it may be taken up in the second round of serious versus
Who is it?
I am appearing in serial number 28, Your Lordship. A little longer time may be given and the state may be directed because the Honorable Supreme Court has said the state merit list has to be prepared by the state. And it is not clear from the counter affidavit if it has been made or prepared or not prepared.
What is your subject?
There are several writ petitioners in this case.
Petitioners are making absolutely vague statement. In the writ petitions, no subject is mentioned. तो किसका result आपको चाहिए? They will not produce the entire result. You tell us list, merit list बनाना. जिसका merit list subject wise होगा ना merit list.
लेकिन जो सुप्रीम कोर्ट बोला उसको तो एडहर करेंगे ना?
नहीं उसको adhere करेंगे only to the extent you are concerned with your candidature. It is not a public interest litigation. You have to disclose your subject.
Your Lordship, however, in compliance of order passed by the Supreme Court in Suni Kumari, we are already publishing the state-wise merit list.
Therefore, we just want to. You have not yet completed.
No, for few subject it is under process.
So, which is your subject? Tell us. Which is your subject? इनका वाला कौन सा है?
That's all subject is the plan still have all subject still like 229 candidates are there in that petition.
We do not know. You have to disclose the subject of each and every one of them.
That I'll make a chart, Your Lordship. I'll make a chart.
Chart it has to be there. No, you are absolutely vague petition subject ने मिल के एक petition file करने से थोड़ी होता. Are you aware what happened in Supreme Court?
Recent one, Your Lordship, I am not aware. Earlier,
Because we have not been interfering with any of the
Yes,
matters
yes.
because Honorable Supreme Court had passed direction that High Court will not pass any order.
Considering this, Your Lordship, we have also already passed several orders that we will not interfere.
In last order, we had Supreme Court especially we have heard specifically said that if any grievances, they can approach to the High Court.
Yes.
I beg your pardon, my lord. I am appearing in serial number 26, my lord. And Nishant Kumar on behalf of the petitioners.
Okay.
My confined submission, my lord, is that in the order of Honorable Supreme Court
Dated?
and rather than complying with the order, the state has been submitting so many.
Your connectivity is not proper. Check your connectivity.
Kindly correct on the face of record, my lord, because
No, I.
Page 29 of that.
There was technical glitch in the meantime. You kindly come again. The Supreme Court has passed some order.
Am I audible, my lord?
Yes, now you are audible.
Pardon, my lord. Yes. My lord, may kindly.
Your connectivity is not proper.
Sorry, my lord. My confined 15th of December 2022, Supreme Court. My lord.
Your voice is not clear. There is lot of disruption. Check your connectivity.
Well, my confined submission, my lord, is that 15/12/2022 order, my lord. That order itself provides for the scheme of appointment.
Your voice is breaking. We can't do anything about
My lord.
it. Your connectivity is not proper. Likhi serial number 26 and 38. You are Mr. Nishant Kumar.
My lord.
You are for the petitioners. Are you for the petitioners?
My lord.
Serial number 26 and 38. Mr. Nishant Kumar, advocate, has joined online, but his voice is not clear. Therefore, his arguments.
Allowed to remove my video. Am I audible, my lord, now? Am I
Yes.
audible?
Yes.
My lord, my humble submission, my lord, is that I am confined to the order dated 15/12.
Yes. 15/12.
Honorable Supreme Court. Where to, my lord?
15/12
has been provided, my lord.
2022, your lord.
I can't hear you. We can't hear you. इनको text कर दीजिए. We can't hear you. Just text it to him. Where is Mr. Pipurwal?
Your Lordship, he is in court number 8.
You are not aware what is happening before Honorable
Received
Supreme
one,
Court. How can you not be aware when an order has been passed in the open court? You must be aware at least what is to be done. We will wait for the order certainly, but we just wanted to know because there are so many matters.
Maybe some other counsel that we are not able to. We have to seek constitution.
इनका लिख दीजिएगा है ना serial number 26 and 38. Mr. Nishant Kumar has joined online, but his voice is breaking, and therefore his submissions could not be recorded during court proceedings. So you are seeking adjournment.
Yes.
And other counsels are not seeking adjournment?
I'm with him only, your lordship.
Lordship,
If there some order has been passed by Honorable Supreme Court, your lordship, then we would also like to see their comment.
The learned counsel for the parties appearing in this batch of cases have submitted that one order has been passed by the Honorable Supreme Court on 22nd March 2024
Yes.
in case bearing diary number 30737 of 2023. But a copy of the order is not available in the website. They submit that the order may have a bearing in these matters and therefore they seek adjournment. When do you want?
After 2 weeks, Lordship, because at some instance the order is being uploaded after some time.
Sometimes
The check करिए तो
sometimes
डायरी नंबर चेक करिए 30737 of 23.
after 2 weeks.
अभी चेक करते रुकिए. You don't know any moment order can be uploaded.
Yesterday I have checked it. Till 20th of
In the morning I have checked alerts. Morning 11.
We trust you. It's not that.
on the
Uploaded नहीं है.
on the earlier
पार्टी का
occasion
नाम दिख रहा है?
सुष्मिता मंडल.
Sushmita Mandal versus State of Jharkhand. Right? Bracket में पार्टी का नाम दे दीजिए. Pose this case on 16th of April 24 in the supplementary cost list.
Because that one number serial number 34.
Yes, how is it different?
Because from that we are not.
At whose instance the matter was tagged?
Perhaps it was taken up together in this different because in the way that we are just challenging because that we have been allotted one particular district that is East Seawood instead of our preference which was West Seawood as per the preference list which was issued by us. But our contention is that the allotment which has been done by the state with regards to those preference lists that has not been done as per the judgment of Soni Kumar. They have allotted the seats which were reserved for 25% of the 25% seats which were reserved for teachers who are already working alone. That has also been given to those individuals. And that has also been allotted to those individuals who are appearing who are not earlier serving as teachers with the government. Because that is our contention. But it is not in my humble submission, but it is not related to
Counter affidavit has been filed.
counter affidavit.
Serial number कौन-सा है?
Plus 34.
34.
Yes.
The learned counsel appearing on behalf, serial number 34. The learned counsel appearing on behalf of the petitioner has submitted that this case has been the points involved in this case is different from the other writ petitions which have been tagged, and therefore this case be segregated. Considering the submissions, let this case be de-tagged from the batch of the matters.
There's one more similar matter, that is 1927 of 23, because that is exactly similar to this. 1927 of 23 minutes.
You see, we can't trust your submissions because at one point of time you say it is similar and then you get it tagged and subsequently you say though it is different. So, what is the date in this 1927?
No date has been given in this.
How is it possible? But it's the date बताइए. 1927 or 23.
Just checked it outside.
Out of
ऐसा कैसे होता आउट ऑफ लिस्ट में नहीं आया फ्रेश फाइलिंग है कि is it fresh filing?
There's in fact, in that particular matter, there's a stay order in which the Honorable Court has directed that one seat be reserved in the favor of the petition.
Pose this case also on 16th of April.
Keep your obliged, sir.
नहीं अभी हम लोग नहीं टैग करेंगे. जब ये मेंशन करेंगे लिस्ट में आएगा तब उसके साथ टैग करेंगे. ऐसे नहीं करेंगे. Mr. Nishan, we could not hear you. Your connectivity is not good.
Item 43 WPS 629 of 2023.
sir, at the outset I will state that in this case Sudarshan Srivastava will assist due to personal reason and not come to the court. The matter related to washing of annexure 6 and payment of arrears of salary matter.
Pleadings are complete.
Yes,
The learned counsel for the parties are present.
Except
Learned
only
counsel for the petitioner submits that this matter has to be argued by Mr. Sudarshan Singh.
Srivastava.
Mr. Sudarshan Srivastava, and on account of personal difficulty, he has not come to the court. At the request of Mr. Sunil Singh, advocate on record, the matter is adjourned and is directed to be posted on 23rd April. Since the pleadings are complete, the parties are directed to submit short synopsis, list of dates, and the judgments which they seek to rely upon latest by 19th of April.
Item 44, WPS 1020 of 2023.
Raised for question of annexure 6, my lord. Appointment letter of the respondent number 8, my lord. Without holding any arms of my lord, his appointment as a senator. That's my lord. Annexure 4, my lord. Page 20. Merit.
Did you participate? There was no answer at all.
No, 2021 में आम सभा उसको कैंसिल हो गया था। उसके बाद ये दूसरा आम सभा 22 में हुआ, वो नहीं हो पाया, वो स्टे हो गया, तो 2021 से आम सभा से अपॉइंट कर वो कैंसिल हो गई। Annexure 4
Where is the order of cancellation of 2021?
Annexure 4 दिखा दे, Annexure 4, page 20.
Annexure 4, page number 20.
20. Merit petition. Later dated 3/9/2022. Lordship got it. May I read it?
Where is the private respondent?
Private respondent is appear.
You have filed your counter.
Well, I filed the counter. The state has also filed the counter evidence. But it was Aam Sabha was held. This petitioner was also present. Rather, she was the first signatory on the Aam Sabha. She never opposed it. Now, subsequently, she made a representation that some.
We'll hear it in the second half.
But
Even a final.
some other date, my lord, because
No, my lord,
I'll be in some other court.
No, my lord, काफी इसमें छोटा सा issue है, my lord. छोटा issue है.
चलिए अभी बहस करिए, चलिए.
Yes, lord.
छोटा issue है.
You argue right now. Give the dates.
Annexure 4 हम refer कर रहे हैं.
नहीं, ठीक से बहस करिए. Yes. Let us see what is your prayer.
Prayer.
You argue your case.
But let it be some other date.
Why is some other date?
But because I'll be.
Petitioner prays for.
What was some accommodation in second half?
Question of.
Some accommodation in the second half.
Second half कितना बजे? 3 बजे? 4 बजे?
नहीं 4 बजे तो केस फिक्स है 4.
आपको नहीं करना मैटर. दोनों को नहीं करना है.
नहीं हम तो अभी रेडी हो जाए. 2:30 बजे रख दिया जाए.
तो ये नहीं पढ़े ना ठीक से. नहीं करने दे.
ये तो टाइम ही ले रहे हैं. टाइम ले रहे हैं.
टाइम तो दे रहे हैं. 3 बजे 4 बजे आ
3 बजे रखा. 3 बजे आएंगे.
आई.
छोटा सा इशू है कुछ नहीं.
कोई बात नहीं. इसको फाइल कर दीजिए.
छोटा सा इशू.
The appearance of state would be necessary.
Where is the state?
The state.
They have filed counter affidavit.
Appearance would be necessary. Submission has to be.
If they are not there, we can't force them to come, can we?
No, no.
We'll appear. We record their non-appearance.
Yes.
Take care of the counter affidavit and pass the order.
Yes.
We don't give invitation card to anybody, right?
Item 45, WPS 1136 of 2023.
Yes, petitioner.
Yes, will take amended petition.
Counter has been filed.
Yes, to the amended petition counter filed.
Continue.
Quashing of annexure 5 at page 26.
by which the claim of the petitioner for salary for the period 1/3/12 to 36/2015 has been rejected, saying, and that too by holding an ex parte inquiry in which the petitioner was never allowed to participate, and saying that you are unauthorized absent for that period, so you are not entitled for the salary.
You had moved earlier before this court?
No, no, sir, coming for the first
In
time.
WPS 1136. What is this? This
Oh,
order has
this
been
is-
passed during the pendency of this.
Yes, Lordship. In the first counter affidavit, they have annexed this. Lordship's order is first order, in which Lordships ask them to pay this lady entire amount and come with the compliance report. In place of this, they have rejected my claim, only retirement benefit has paid and the arrear of salary has not been paid, which Lordships have considered annexure 125 that the allotment has been asked. I was not relieved, I was working in the Simaria hospital throughout, I retired from there. Everything as Lordship has considered on the argument on the last occasion. In spite of that, ex parte inquiry has been done during the pendency of the writ application and they have rejected my claim.
The ex parte inquiry.
Yes, ex parte inquiry. If Lordship comes to its chronologically.
Kindly read it.
Yes, impugn order at page 26. WPS 113623 उमा चक्रवर्ती ब्राह्मण राज्य सरकार एवं अन्य मामला माननीय उच्च झारखंड न्यायालय झारखंड में दायर वाद में माननीय न्यायालय द्वारा आदेश पारित किया गया है. The admissible amount should be remitted to the petitioner in her bank account, which should be mentioned in the counter affidavit itself. In case admissible amount is not remitted, reason be also mentioned in the counter affidavit. उक्त के आलोक में वस्तुस्थिति के सत्यापता की जांच हेतु हस्तोशास्त्री कार्यालय के पत्रांक 15/7/23 द्वारा गठित 3 सदस्यीय संयुक्त जांच टीम के द्वारा श्री उमा चक्रवर्ती तत्कालीन पक्षकार्य श्रेणी 1 के द्वारा दिनांक 31/3/12 से 15/7/15 तक की अवधि का रेफरल अस्पताल सिमरिया में कार्य किए जाने हेतु दावा के आलोक में जांच की गई. संयुक्त जांच टीम के द्वारा आलोचना अवधि के चक्रवर्ती के द्वारा किए जा रहे दावा के अनुसार रेफरल अस्पताल सिमरिया के किए अथवा नहीं किए गए कार्य.
This order has been passed behind the back of
Yes,
the
Lord.
petitioner. At the back of the petitioner. That's right. You were supposed to give reasons. So in order to find out the reasons, you have done this. That is
Three-member
perfectly
committee
all.
has been constituted, and on the report of the three-member committee.
No,
there
we
is
appreciate that. But one adverse order has been passed. You give him an hearing. Whatever documents you are referring to, give him a hearing to that. That is it. Isn't it?
And Lordship sees the one more important point. The impugn order was passed on 25/7/23. Lordship see, and in the first counter affidavit, page 32, they have annexed this so cause that shows the hindrance of the respondent towards this lady Lordship. Annexure page 32 of first counter affidavit, so cause has been given after the impugn order. Impugn order is 25/7/23 and so cause was given 26/7/23. First counter filed on
No,
31/7.
this is not they have just collected the material and then they have given you a show cause. Then after that is not the final order, right? They have issued you a show cause as to why this should not be rejected or whatever.
They have rejected the impugn order which is before the Lordship. They have rejected my claim by constituting a committee ex parte in which I was not allowed to participate. And thereafter they are asking me a show cause in terms of the impugn order.
That's right. So therefore, whatever be the show cause, or they have taken a decision and then given you the show cause, right?
First they could have asked me the show cause.
It is basically their internal deliberation on the basis of which they found that you are not entitled.
Yes, yes.
And then they have issued you a show cause. But in response to the show cause, now you know what is their stand, right? In response to the show cause, you file your response
filed.
and they will pass an order without being prejudiced by this order.
As Lordship.
That should be sufficient.
Lordship.
If they find anything favorable
Lordship,
in your favor.
Lordship is right. If Lordship only one humble submission, annexure 1 to 4 may see. Only that may come into the Lordship's order.
No, they will see everything. Why should we bother about it?
What they have said, that was what I am submitting, Lordship. They simply say they have not I worked. And the person who issued us a letter in my favor, only they are disputing the letter of civil surgeon who's saying that he worked from 12 to 15 and I don't relieve him to the transfer place because of the nurse is not available.
So
there.
whatever be your stand.
खाली वो फंड भी रिलीज हो गया मेरे फेवर में.
फंड रिलीज होने से आपका फेवर में तो फिर क्या होगा? फंड अगर मान लीजिए आपका कोई एडवर्स ऑर्डर आपके पास रहेगा,
आप जो बोल रहे हैं,
unless this order is set aside,
Yes, Lordship.
it cannot be remitted.
It cannot be remitted.
So we will ask them to pass a fresh order without being prejudiced with this. That should be sufficient.
Giving him a hearing.
And give him a hearing, because you have issued to him a show cause pursuant to your internal inquiry. This at best can be said to be an internal inquiry and no more.
Right.
Right? Where is the show cause which they have given?
In the first show cause, Lordship, page 32.
First counter.
First counter.
Page 32.
Counter affidavit dated 31/7/2023.
Lordship, what? Page 32.
Just a minute. 31/7. Page number
32, Lordship. This shows a predetermined mind. They have rejected my claim and asking me to submit my reply in 24 hours.
Just page number 32.
Yes,
right?
Lordship.
ये जांच प्रतिवेदन आपको भेज दिया?
यही वाला जो इम्पीन ऑर्डर है
बस इसका कोई मटेरियल, कोई डॉक्यूमेंट्स जो इसमें है?
कुछ नहीं.
You will get inspection of that. What do you want?
They have not allowed me to participate.
They will.
They will. After Lordship's order, definitely they have to.
They will give you the inspection of the records.
Yes, Lordship.
Right? You give him inspection of the records. लिखिए. Heard the learned counsel for the parties. This writ petition has been filed for the following relief. Initially, the writ petition was filed on 27/2/2023, wherein following prayer was made. On 19/4/2023, a submission was made by the learned counsel for the petitioner that admissible dues of the petitioner has not been paid to her, although she superannuated on 31/10/2017. And that the reason for non-payment was unknown to the petitioner. In such circumstances, and the counsel for the respondents prayed for 4 weeks' time to file a counter affidavit. In such circumstances, a direction was, the respondent was granted time till 26/6/23 to file a counter affidavit. But in the meantime, admissible amount was directed to be remitted to the petitioner in her bank account. And it was also directed that this should be mentioned in the counter affidavit itself. It was further observed that in case admissible amount is not remitted, the reasons we also mentioned in the counter affidavit. The learned counsel submits that pursuant to the order dated 19/4/23, a committee was constituted and an order contained in memo number 1242 dated 25/7/23 was passed wherein the claim of the petitioner has been declined. The learned counsel submits that the report of the committee is ex parte and no opportunity of hearing was granted to the petitioner. Rather, vide memo number 364 dated 26/7/23, a copy of the said report was forwarded to the petitioner and the petitioner was directed to submit the explanation within a period of 24 hours. He submits that basically the respondents have sought to give a post-decisional hearing in the matter. The learned counsel submits that the amended writ petition has been filed challenging the decision of the committee contained in memo number 1242 dated 25/7/2023. The learned counsel appearing on behalf of the respondents has submitted that the inquiry report, the report of the committee is primarily a deliberation of the members of the committee, and before taking a final call in the matter, a show cause was issued to the petitioner on 26/7/2023. He submits that if the petitioner would have responded to the show cause and would have pointed out any material in his favor, the decision could have been taken accordingly. The learned counsel has submitted that the petitioner may still respond to the show cause dated 26/7/2023 and appropriate decision will be taken. Okay? Same committee will take the decision?
The civil surgeon will take.
Civil surgeon.
The civil surgeon has
The
already
learned
passed an
counsel
order.
submits that.
Though the civil surgeon has already passed the order on 25th 7/23 on the basis of the report of the committee.
Well, that's what I am submitting, Lordship, that the inquiry report and participation by the committee was there, not allowed. Now, the punishment, indirectly say punishment imposed by the Annexure 5 and then issuing this.
This is not the committee report.
No, this is the punishment in that.
This is the punishment. In fact, not the punishment, this is the order, rejecting the claim of the petition.
The learned counsel for the respondents has submitted that order contained in memo number 1242 dated 25/7/23 has been passed by the civil surgeon on the basis of the committee report.
Yes.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that initially when the writ petition was filed, the petitioner was seeking mandamus from this court. And it was the case of the petitioner that admissible amount was not being paid to the petitioner. Consequently, a direction was issued on 19/4/23 to pay the admissible amount and cite the reasons for non-payment of any portion of the amount. It appears that the respondents constituted a committee to consider the grievance of the petitioner, and a report was also prepared. But the civil surgeon passed order contained in memo dated 25/7/23 in bracket Annexure 5 against the petitioner without granting an opportunity of hearing to the petitioner. And the show cause was issued to the petitioner by memo dated 26/7/2023. That is 1 day after the impugned decision dated 25/7/2023. This court is of the considered view that such a course of action is not permissible under law. And accordingly, the decision dated 25/7/2023 is hereby set aside only on account of violation of principles of natural justice. The respondent number कौन है? The civil surgeon cum medical officer, respondent number 5, is directed to pass a fresh order after granting an opportunity of hearing to the petitioner. It is made clear that the petitioner would be entitled to inspect the records of the internal committee on the basis of whose report the impugned order dated 25/7/23 has been passed. For the aforesaid purpose, the petitioner shall approach the civil surgeon on April 29th.
सर्टिफाइड कॉपी
मिल ही जाएगा, मिल जाएगा ना, मिल जाएगा,
ठीक है,
वो बताएंगे तब मिलेगा.
नहीं
On 29th April 2024 at 11 a.m. After inspection, the petitioner shall file a show cause reply to the enquiry report within a period of 1 week from 29th April. No, by 6th of May. By 6th of May. And thereafter the civil surgeon.
Copy of inquiry report also provide me.
आप जाइएगा, सारा इंस्पेक्शन आपको मिल. इंक्वायरी रिपोर्ट आपको इसके साथ ही भेजें, इसके साथ ही भेजें. जांच प्रतिवेदन अनुलग्नक है आपके शो कॉज के साथ. The civil surgeon shall pass a fresh order after granting an opportunity of hearing to the petitioner by 31st of May 2024 and fresh reasoned order. The order be communicated to the petitioner through speed post. This petition is accordingly disposed of. The impugned order has been set aside only on account of violation of principles of natural justice, and this court has not gone into the merit or otherwise with regard to the claim of either parties. It is for the civil surgeon to pass appropriate orders in accordance with law, taking into consideration the applicable rules, circular, inquiry report, etc. This petition is accordingly disposed of. ठीक है, सेकेंड आपको